Field Zoning Board of Appeals at 7:04. Please stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
It's hot up here.
Yeah. Madam Secretary, the roll call, please.
Andrew Abanowitz.
Here.
Tim Neville.
Here.
Mary Ann Turner, here. Kelly Davis.
Here.
Charlie Masterbirdy.
Here.
Rick Stroney.
Here.
Rob Kwasnicki.
Fire evacuation notice. There's two ways out of this room. One is behind the audience, down the stairs, and out onto the town green. The other is to the right of the audience, down the stairs, and out into the parking lot. Town attorney's report. Everyone will take notice that we received that from Lori today.
Wait a minute, we got another one?
Yes, it was not in our packet, if you want to look through it. There's,
You have to stop doing this.
We have to stop losing staff.
You,
I do apologize. We tried.
hang on a minute. So the town attorney report. I had some questions on the one that I had. Is this different than the one that I read last night?
This is a general update on pending litigation for all land use boards in the town.
This isn't the town attorney report that you asked for.
Right. This is
This is not the staff report that you requested. This is the actual general town attorney report on pending land use cases.
Okay, so
Uh,
It's informational.
Yeah.
So through the chairman, I see I'm looking at number 1, number 2, and number 7. From what I'm gathering here, do we have any idea of when these things are coming? Are they just still sitting in litigation, or they haven't got to court yet? Is that what it means?
Well, yeah, I mean, the item number 1 has just begun the litigation process, and 2 and 7 are at various points, and on the second sheet, the town attorney's kind of summarized what's going on with activity.
Where'd you get that one?
It came with
They were
this one.
penned together.
If you want to take a look through it,
Came together.
so.
You can have mine if you want.
That's all
Can't
right.
find it.
Okay, so all they are is they're just still pending, and we won't-
Correct, yeah, they're in litigation, that's, any other
We'll try to do better next time.
Any other questions on the town attorney's report? Seems like none. So now we'll move back into old business, and I am recused from that matter, so I will be exiting the room and turning it over to Vice Chairman Neville to handle this hearing.
Thank you very much. Good evening, everyone. How you doing? At the last meeting, as you remember, we tabled the meeting so that we could have an opportunity to consult with our attorney. And we have gotten some missives back and forth, but unfortunately, we're not able to meet one of them before this meeting. But bottom line is that in order to get started again, we need to take the hearing number off the table and vote it back so we can continue the hearing. So could I have a motion to that effect, please?
So moved.
There a second?
Second.
Second. All those in favor, raise your hand, please. We're back in the meeting, folks. I think, well, you were seated last time. We'll formally see Rich Stoney to make a full, basically to take the Mr. Urbanowicz's place here. With that said, we've had a lot of paper come our way in the last, if you've noticed. And some of it, I'm sorry that we couldn't have the meeting because with your support, we were able to table the last meeting.
Yes, of
which was in April, believe it or not. And the meeting, we couldn't have the meeting in May. And I know there was some documentation that came out then. We all have it. I just don't know whether you want to go through, because some of it, I believe, was yours. Correct me if I'm wrong.
That's correct, Mr. Chairman.
Okay, if you would like, you could go through that.
Would I like, first of all, for the record, Carl Landolina representing the appellant, Raffia Farms. So what I've done to start is to, at the last hearing, I gave you a package of information. I looked at the minutes. It was actually 39 pages of documents. Unfortunately, I did not number them, so we were kind of fumbling our way when we were trying to speak about them. So I don't want to, muck up the record, but I'm going to give you each a packet of the same documents, except they're numbered now.
Thank you.
Pages, so that if I say so-and-so wrote a letter, it's on page 26, and I apologize for that. So that's the first thing I have, if I may approach.
Yes, you may.
Bertie, how are you?
Good, thank you.
Don't, the copy machine does that. Yeah,
Amazing.
it's exactly 39 pages. Right, there's nothing new there, that's the original 39. So the next thing I have, and I think staff may have given you this as well, but I'm going to give you another set. These are the first zoning regulations that the town had in effect, and they were effective March 13th, 1925. So, and again, I numbered those pages, so that if we're talking about pages.
Thank you.
And then, Mr. Chair, the last item I have, copies of the zoning ordinance from 1955. I think staff may have given you that as well, but again, I numbered the pages. And we're going to talk about that when we talk about the zoning map that you should have in your packets already. That's a fairly large document, so I didn't provide a copy, but I don't, what's that?
Sure we have that. That's what was out first.
Yeah, Rick's got a copy of that.
There's an attachment, but there's a full size.
Yeah.
Don't need my magnifying glass today?
That's why it's, I made it bigger.
Is that the one that you sent? Is this different than the one he's given us? This is the one I made a copy of.
Can I just see it just for a second?
Yeah, it's the same one.
I printed it already. I thought.
I think it's probably just a larger version of what Rick sent out to you, and it's a map of the whole town, so it's kind of hard to see in anything other than the larger version.
You want to look at this?
Let me get to it, I guess.
Okay.
I'm assuming that's this? Yes.
I can't read that.
Yeah, but that.
That's what that
this.
is?
Yeah, there's no way you're going to see this property on there.
You mean when I was using my magnifying glass?
Did you see it with Mary Ann with your magnifying
I
glass?
started highlighting all over it? Yeah.
Yeah.
Hurting my vision when you send out these kind of things here.
Well, no, I didn't send it out. Your
You sent
zoning
it to him,
enforcement
though.
officer sent that to you. And I'm glad he did. It's something that you're gonna need to look at and we're gonna need to discuss. But just, since it's been 2 months, with your indulgence, I'd just kind of like to do like, when you watch a show on Netflix, it says, what shows you what previously happened, in case it was 6 months since you saw the last episode. But the question here is whether the property at 110 Raffia Road, which is currently owned by Raffia Farms and has been owned by them for several years, whether that property, which is currently being used as sort of a contractor's yard, contractors do business out of that place, whether that property or that use is a non-conforming use, which is to say that the use has been ongoing, and since its inception, or at the time of its inception, it was either prior to zoning regulations in effect that would impact that property, or it was otherwise a valid use at the time of its inception, or it was a valid use at that time and then became a non-conforming use at some later date because the regulations changed or the map changed or what have you. So the concept of non-conforming uses, I'm sure you're all aware of them. The colloquial term is grandfathered. That's what, most people will say, that the use is grandfathered. So under current Connecticut law, once a use is grandfathered or deemed non-conforming, then unless the use is abandoned, and right now the status of that law, in order to, there were a lot of zoning regulations which said if you stop using it for that grandfathered or non-conforming use for a period of 1 year, 2 years, or what have you, you were deemed to have abandoned it, whether you intended to or not. Then the statutes changed 30 years ago or so and said, look, the time frame doesn't matter. You must show an intent to abandon the use. And we argued back and forth for 30 years as land use lawyers as what does that mean, intent? And so the legislature said, the heck with it. Intent can only be shown by really, and I think Maria Elsden puts it very eloquently, I guess, in her opinion, that says you basically got to stand up and say, I don't want to do this anymore. And we tell our municipal clients now, get an affidavit, put it on the land records, and they say, okay, you've abandoned the use. I mean, there's many cases that go back many, many years. There was one of a hotel downstate where it hadn't been used as a hotel for 30 years, and then someone came in and tried to revive it as a hotel, and the courts, of course, the town said, no, you've abandoned it. It's been 30 years. You've done other things with it. And the court said, nah, there's no evidence that they really intended to abandon it. So that kind of concept's been done away with by the legislature that says, hey, you really have to manifestly, expressly determine and state in some fashion that you're abandoning the use. So there's no evidence that this use, whether you think it's non-conforming or not, has ever been abandoned. It's been used since basically the same types of uses since its inception. And I know one of the neighbors testified that when they bought a house there, they didn't notice the use, or else they may not have bought the house there. But under current law, in terms of our discussions, you and the ZBA, that's of no relevance, because there's no evidence of any intent to abandon the use. All right, so we can sort of start there. Just to go through the 39 pages, and I won't go through all of them, all right? Now, the reason that these dates are important, even though you had zoning here in Enfield for most of the times that are stated in these dates, one of the concepts of as Maria Elsden states in her, or Maria's name's probably not on it, but I know she wrote it. Jim signs everything now. But so one of the concepts is that the use is known in the neighborhood. All right? Everybody knows it's there. That's one of the concepts of a non-conforming use. If you're hiding something in your basement, and even though you've been doing it forever, doesn't mean that it could be a grandfathered or non-conforming use, because it's not known in a neighborhood. All right? So some of these facts are to prove how long it's been going on, i.e. before zoning or what have you, and to prove that this was something that was known in the neighborhood. People knew it. So the first one on page 2 is by Mr. Stremper saying, hey, he moved here from Broadbrook in 1971, and there was construction and concrete business on that property from 1971 when he moved into town till now. On page 3, you've got something from Brendan Begley saying Bob Higley, who once used the property, had worked out of that location as well. All right, Bob Higley apparently did some work for Brendan and his father. Number 4 is a letter from Rosemary Zachary. All right, and she is related to the original owners, well, the owners who actually started this business. And you can see in page 2, she says, "My name is Rosemary Boudreaux Zachary. My great-grandfather was Carl Schneider." And she says she had fond memories of hours spent on the farm, learning about farm work and ethics. And the last paragraph, "The property has always been a construction site ever since my great-grandfather came from Switzerland, started his own business." Okay? So we've got a relative of Carl Schneider, who was the gentleman who first started.
Excuse me, you
Yeah.
referred to it on page 2. This is
I'm
page
sorry,
4.
page 4.
Okay, thank you.
Yeah. She doesn't list the date, but she said when he first came here, and I think there was testimony last time about when that was, when Mr. Schneider immigrated here from Switzerland. Page 5 and 6 is a letter from Karen Warner, who says, "I've been living next door in the area for 29 years." And she talks about the use of the property. The next few pages are minutes, and they run from page 7 to page 15. These are minutes of a planning and zoning meeting in 1992 when a subsequent owner, Bull Construction, Mr. Bull was a contractor from Windsor. He built a lot of homes and commercial businesses, and he owned this property for some years back in the late 80s and the 90s. He was the one who built what this record is about is a special permit and a subdivision approval for 2 rear lots that go behind this building. They had, and there's a couple of maps attached, and you can kind of get a flavor of what Mr. Bull did. Now, the reason I pointed to this is that there is, I was hoping for some discussion on the record by a Planning and Zoning Commission saying, oh, yeah, that's next to that business, and there isn't, but there's a mention of the building. So everyone recognized that in 1992 and before, and it's even shown on the map. The existing building has always been shown on the maps that follow on page 16 especially. So it is mentioned there. 18 is just another map. Page 19 is from a gentleman named Robert Ball. He owned a barber shop at 85 Raffia Road from 1969 to 2020. And he says the property in question has always been associated with local small businesses. He remembers one from his recollection in the 50s when Mr. Schneider owned it as a farm equipment operation. Guimond Construction did concrete work after that, then Bull Construction, and then RAH, which is Bob Higley's business. So he kind of gives you a history of the property from his understanding of it. Next one is from Mitchell Raffia. And this person says the dates are approximate, but from their understanding, at least 1952, when he spent time on the family farm. when he was 12, so he would have been born in 1940. My math is correct. That's when Schneider's machinery business was located there. He says they built new equipment and modified existing equipment as well as repairs. And then goes, Guimond took it over, Bull Construction, so on and so forth. The next 3 pages are a street map of the town, and I know they don't do this anymore now that we've got maps on our phone and everything, but I remember back in the day, every town had this sort of street map, and they'd come to your business and say, hey, look, we're going to hand these out for free for people who want them. Do you want to advertise on it? And in this particular one, I think on page 22, I think it's underlined, you can see a spot where it says concrete contractors, the Guimond Construction Company, 116 Raffia Road. This was a larger piece, and 116 was the address for some period of time. And then if you go to the next page, 23, you actually see where it was located. They had a little stamp on it, and so all the advertisers got, their operations got shown on the map. So again, known in the neighborhood, that's why that's sort of there. Page 24, R.J. Toby said, I lived in Enfield since 1941. It's always been a farm equipment and construction. All right, and he talks about the maintenance of it. Page 25 is of the Lassards, who moved in 1979. Talk about it being there. Page 26 is from Daryl and Catherine Crowley. And after the first sentence is, both my wife's family and mine have roots in the town of Enfield dated back to the 1800s. My wife's family has resided on Raffia Road, and we currently own property there. The property at 110 has always been a construction-type property with various businesses operating out of there. My wife recalls from her youth years a farm construction company, I believe, known as Schneider. And again, they go through the history of the property. Another gentleman on page 27, Jack Collins. I've been a lifelong resident of Enfield for 75 years, and he remembers back when it was owned by Guimond Construction. Page 28, another letter going back, and somebody 58 years old remembers it as Guimond. Page 29, Stephen Toby. Lived in Enfield for 84 years, and as long as I can remember, the property was a construction yard dating back to the 30s. Home to many different companies, from Carl Schneider in the 30s to Guimond Construction. Bless you. And then Frank Toby III, saying he's been in town for 60 years. He remembers the construction company there. Page 31, maybe a relationship. They're all related. Maybe the Tobys, I don't know. This gentleman says, I've lived in Enfield for 86 years. And the property at 110 has been a construction yard dating back to the 1930s, housing several construction companies, Schneider, Guimond, so on and so forth. Next one on page 32, Mitchell Wojner. I, Mitchell Wojner, have lived on Post Office Road for 85 years. When I was around 5 or 6, so that goes back 80 years. I went to see Carl Schneider of Custom Farm Equipment on 110 with his father, Raffia Road, to have a tobacco setter and a tobacco wagon built by Carl. So 80 years ago, this gentleman's family, I'm not a tobacco guy. I assume a setter maybe puts the plants in. I don't know, but not a farmer. So, but 80 years ago, Mr. Schneider was building custom equipment for people, it's selling it directly to them, sort of as a retail operation. Then you got Anthony Spazzarini talking about his knowledge of the property. Mr. Spazzarini, as you know, has been around here for a long time. And then the rest of the letters are pretty much the same. So we've got evidence that this operation goes back into the 1930s, most likely. I explained last time that when I went to look at zoning records, the zoning commission, the regulations started in 1925. The minutes go back to the 30s for a few years. I think there was 3 years. And I didn't see any mention. What you would see typically when you went to look at the records from those years, you would see they had a meeting, and I think it was $25 to get a zoning permit, and then you would see just a list of names. And it looked like they would vote. If there was 10 people on that list looking for zoning permits, they would vote on all of them at the same time. That was it. Didn't look like they looked at any paper. It was just, okay, approve the zoning permit. That's how the minutes read. So for the few years that there were meetings, there's no record of Schneider in there getting a zoning permit. Not saying they didn't. I'm saying for the few years, there's no evidence of it. And as I mentioned before, I've seen towns that had zoning regulations back in the 20s and 30s. It's not unusual for there to be a large gap starting in the mid-30s to like 1945 because of the Depression, and then World War II. I don't know what kind of business they were doing, if anything, who knows, but the zoning commissions, the typical meeting minutes that you might find sort of disappear for a long time, as they did here in Enfield, and then started up again in the late 40s. And of course, when Mr. Starr started building homes in the 50s, then there's piles and piles and pages of regulations. So that's sort of the history we have here. So, as I also mentioned, and I think if you go upstairs to the planning department and you ask for, which I've done a number of times, ask for copies of all the regulations, they'll bring out a Redwell like this. It's a little bigger. And all the regulations that can be found in town are in this one little file, or big file. And the 2 sets of regulations that you have are in there. And then you ask for the maps, and there's more maps than sets of regulations. There are some maps that are just POCD maps. There are some maps called zoning regulation or zoning maps. The first one, I think, goes back into the 25, maybe the 30s. And the only thing that's on that map is zoning for properties in Hazardville and Thompsonville. If there's another map that shows the rest of the town, it's not in the file. And I think Rick would confirm that. It's not there. So then, as you go forward, maps started coming, entire maps of the whole town start being produced. What I have here, what you have in front of you, is a map dated 1961. And I guess I'll bring, if I can approach, maybe it might be easier if you at least have 2 of them to look at.
Slide over here if you want to.
Thank you.
So what I've circled is 110 Raffia Road. So that is a map that was produced in 1961 showing that 110 Raffia Road was not zoned as a residential piece of property on that map. It was actually zoned as a Business A zone, I believe, if you go to the index. Now, I believe there was a map before that, between the 30s and that map, maybe in the 40s or so, that showed that in the R17 zone. But for some reason in 1961, and, you know, there's no records that I could see that show how, why, or for what reason, the town, that's an official zoning map, it's kept with the other official zoning maps. Someone saw fit to say, well, that doesn't reflect what's actually going on out there. That's not a residential use. There's something else going on. And it's not unusual to see properties in zones that dictated what they were being used for, not what the plan was for. So now we'll talk about what that means in a few minutes when we look at the regs. But clearly in 1961, the town had that zoned as a non-residential piece of property.
I know what it is, but it's.
Now, you see on across the street, a little further north, I guess, is a larger piece. That's the plaza. That's always been there. That's still there on Raffia Road. But the small piece, now today we'd call that spot zoning, but back then, I don't know if that was a concept that even existed, but the town recognized it as a non-residential piece of property. Do you guys need to see the larger map, or did you guys already? Yeah, okay, thank you. So, if you'd like, I'll move on, or you want to, yeah. Yeah, it looked like, Mr. Chairman, you were looking at,
I'm just trying to get the track of it. We have a number of maps here,
yeah.
and I just want to get the, I know several of them were signed by the secretaries of the commission, I believe.
There's,
72?
there's one that one of the neighbors submitted in the 70s, which is a map that's been revised 3 or 4 times, and it's got Mr. Spazzarini's signature
That's the house.
on,
They start talking.
underneath the dates. Yeah.
Do you have a copy of this map? Looks like a subdivision map.
Yeah,
That's GIS.
I have no idea.
Yeah. You're trying to point out, if you look at,
It has an X on it, it's marked 110, and it has a building.
Correct.
With a square on it.
that's our property, the
Do you
building.
think it's the house, or do you think it's
No,
shed?
that's the shed, if you want to call it that, the
Because
building.
on the, when you look at all the maps that we received during the time that they went in front of planning and zoning about the subdivision, they never called it a construction building or building. They call it a pole barn, which is an agricultural use, and then on the actual maps itself, it calls it a shed.
Yeah, the existing shed on
Yeah, it's
page
on one of the-
16. Correct.
16.
Yeah, if you look at what we just went through, page 16, this is, when I talked about the 2 lots that were being, the rear lots were being created, they were going to take the original house, the farmhouse.
Which is still there, right? That house that's there now, isn't that the original farmhouse?
Yeah, okay, yeah. I suppose, I'm not familiar with the property as much as you probably are. I think it is. So they were going to have this kind of weird configured lot to go along with the farmhouse, which is what you see on page 16. of what I handed to you. And then they just reconfigured it so that the house is on a smaller frontage lot with nothing, sort of like two pieces kind of at an angle. So the shed, the barn, the manufacturer, whatever you want to call it, is self-contained on a lot. It's the only,
Lot number 4,
it is, correct.
and it states in the minutes that lot number 4, I forgot who said that, I'd have to go look. It says, it was asked about that building.
Right.
And it said, if the lot was going to be used, that shed would be removed.
Correct. Right, it didn't. And then after a few years later, they reconfigured it, the lot number 4, to include, and only include the shed.
We have documents on that?
Yeah. It's,
We have one that does it, it's 2001, wasn't it? I think it was 2001. It's on the back page of the one that had the 89.
Not this one, right?
yeah, I think something Rick gave
As
you.
part of the re-subdivision.
Right.
It was the third
Or lot number
re-subdivision.
4 gets squared out.
So what is 118 today was lot number 1 prior to the re-subdivision and lot line change. So that the pole building was on the same lot as what was 118.
Colored slides, yeah.
I've got them.
I've got two.
So the building never came down. There was a re-subdivision, so that the lot on which the building stands is a conforming lot. It has sufficient frontage area, setbacks, and, again, under today's non-conforming use law, whether they thought they were going to tear it down, even if they might have torn it down, it may not have been abandoned as a use, but we don't need to go there because it was never torn down, and subsequent owners used it in the same manner it had been used since the 1930s.
Did any of those businesses ever register with the town? Because I couldn't find any place that any of them registered
I don't know if they did or
Town.
didn't. You mean like
for
as
this
a,
spot. They were businesses that belonged in other Suffield or Summers or
right.
something.
Yep.
But for some weird reason, they never registered, as best I can see, that this shed was used as a primary area for these businesses to run. It looked like they were just dumping stuff there.
Well, I don't know, the letters respectfully would disagree with you, that there were many operators there using it.
And I'm not disagreeing that
Yeah.
you don't have 30 letters telling me that somebody drove by it at some point.
Right.
But I can't find anywhere where they actually registered as a business there.
So I'm not sure the significance of that because, if I, if I have an office in Windsor Locks, and if you look up Fahey Landline Attorneys LLC, you can, on the Secretary of State's website, you would see that that's our principal place of business. But if I opened a satellite office in Enfield,
You'd register with the town that you had a satellite office and you'd pay personal property tax.
I'd pay personal property tax, but I wouldn't need to be otherwise registered with, when you say registered, I'm not sure what that means. I know as a,
I know as a small business owner, I needed to let the town know where I was
because
located.
you're doing business in Enfield.
But you just used the scenario that you'd be doing business in Enfield too.
Right, but if you looked at if you relied solely on the Secretary of State's office, which some staff do, they look there.
Right.
Well, how come Lenny Bull didn't register? Well, Lenny Bull's got an office in Enfield.
Well, I
I don't
thought
know,
Kegley had
or
one
I'm
on
in-
Sapphire Street. So his mail probably went there. The question I can't seem to get clear is, was the businesses legitimately paying personal property tax? And I
I-
can't find any of them that show that they actually did that, which means they were just storing stuff in a barn,
Well, outside as well.
which doesn't, okay.
Yeah, I don't know. Did you, I mean, I don't need,
See, there's 4.
I don't want to cross-examine you, but you go back for 80 years and see who paid personal property taxes at the
Well,
property?
one of the things that you gave us specifically in the 20, 30, 40, 50 pages you handed me,
Yeah,
The last one actually says that. I want to remind people of the town to look at the amount of taxes.
Oh, well, I didn't write the
I'm
letters.
assuming
Yeah,
if they paid their taxes.
well, they're probably talking about real estate taxes. And we
Personal
still,
property tax.
yeah, whatever taxes, yeah.
I'm with you.
But I think the point I'm trying to make, and I think I made it, but I'll make it again, is that, you know, if I'm doing business under fictitious name in Enfield, like I'm Carl Andolina attorney, but I'm doing business as zoning law guru, fictitious name in a lot of ways, I would have to file a trade name certificate. But I'm doing business under Carl Andolina in Enfield and in Windsor Locks, and that's my principal office. I'm not going to file a trade name certificate. I would file a declaration every year, so the town of Enfield would get taxes on my computers and such, but you know,
To the chairman,
Yeah.
to the staff, do we see that these businesses did that?
I couldn't find anything regarding taxes other than, I asked the question to the tax assessor, and his response back was for at least the last, since 2013, it's been taxed, the property itself has been taxed or assessed as open space property.
Would, that included this shed?
Yeah, but it was open
Right.
space originally, and
Not
prior
as
to that, there's records for when it was under the ownership of Margaret Dupree, that it was taxed as farm property when it was, 6.1 or 6.2 acres prior to any subdivision.
Which is when I kept diving into all this. I can't find where there were legitimately businesses.
There weren't any business records for that address for any of these companies, other than 1 year, Gamond Construction registered that as a mailing address. I think it was 1995. None of the others had an address there. They had, Bull Construction had their address out in Bloomfield. Higley had it at Sapphire Street. There wasn't any way to confirm anything. There wasn't any record for Snyder's business if he had one there. And there weren't any other records pertaining to that.
So that it is possible that the personal property tax would have been paid off of their other sites, maybe? But I would,
Well, I'm assuming if they had the business in Bloomfield, that they were being taxed because that was their office, that was their construction facility.
Just a question, Mr. Michelli. In terms of that stuff, Commissioner Turner was asking a question I had the same curiosity about. If these people you haven't found it in your research, right? You haven't been able to find any of these people except for Guimond who actually were listed for 1 year as a business in Enfield.
He used the address of 116, not 110, but 116, because that's a mailing address. And I'm pretty sure it was 1995 when he filed with the Secretary of State's office.
What's the traditional way that a business that comes to town, whether they rent or they buy, gets kind of on the books? If I came to town and I wanted to start a business, what would be the process that you folks would recommend to me?
Well, as long as you were, the use was allowed in that zone on that parcel, you may need either a site plan or a special use permit, depending on the type of business it is. So it would range anywhere from special use permit to a site plan down to a zoning permit if that use has been on that property before. And we would process it through based on the records that we have at hand.
So you would end up, me, the person who wanted to start the company, would end up in your office or in the P&Z for application to whatever they had to do. Would that be correct?
That's correct.
Okay. How many people do you think don't do that? And would that be considered legal or illegal if they didn't do it?
Well, if they're operating a business without an approval, at the very least a zoning permit, we would approach them. We've done it. We've done it numerous times that, they're operating without an approval for that site. Sometimes, many times, the uses are not allowed, and we wound up going through a situation similar to this.
Okay.
Or they just file whatever paperwork's required to get an approval.
See, the question that's bugged me, and I've gone through these things 1,000 times every day, I feel. At least that's what my wife tells me. But I looked at the tape again this morning, just to verify some of the things that I thought, is that when the property was purchased, okay, and the warranty deed was put out there for Mr. Raffia, I know the warranty deed, they signed it and all this stuff. I understand all that stuff. But it also says that, and I may be wrong on this, so feel free to correct me. Said premises are subject to building line, and zoning restrictions to the town of Enfield. I'm not a lawyer, but I'm looking at this stuff and saying, that means that I've got to abide by the zoning, I've got to abide by the property lines, I've got to abide by all those things that are quote-unquote legal. And I'm agreeing to that when I put my name and stuff on this deed. Am I wrong, Mr. Rochelle?
No, that's usually, and that's on certain properties, that's quite often the case in the deeds.
So with all due respect to Mr. Rochelle, he's dead wrong about that. You'll find that language in 99%. It's basically saying that I give you the property, and if you can't use it for your intended purpose, you understand that there's zoning that applies, that's on you. It doesn't mean, that's not a warning, or that's not a, for instance, all right, let's go back for a second. I want to put this in context. If I'm running a barber shop, okay, and it's a legal use, whether it's been there since 1800 and it's a non-conforming use, or I just started it 30 years ago, and I want to sell my barber shop to another person who wants to use it as a barber shop, is Rick telling me I have to go in and get a zoning permit? No. It's a use that's exactly like that. You just go in and you use it. If you want to talk to Rick or staff about it, you can. But there'd be nothing wrong with using a barber shop as a barber shop. I don't need any permits for that. I'm not changing the outside. I'm not enlarging the parking lot. I'm not doing anything. That's a permitted use. I can go in and do it. I don't need anything from anybody.
But you would file with the town that it was a business, here's your address, and you're doing business
If I was, in
there.
fact, if that was my principal place of business, yes. If it wasn't, then I wouldn't even need to do that, unless I was calling it Billy Ray's Barbershop and I want to do a trade name certificate. See, here's the other thing. Let's talk about taxes for a second. I know I'm going afield. How many people have come to you and where the zoning enforcement officer says, you don't have a building lot, right? And they say, wait a minute, I've been paying taxes on a building lot for 50 years. You ever hear that one before? Hundreds of times. Whether someone was paying taxes on it or something has nothing to do with the zoning of the property. Maybe the person was being taxed improperly. I don't know. But the tax situation has nothing to do with the use of the property. They're totally two different things. And your question, Mr. Chairman, is that there are circumstances when you don't need anything from the town. You just don't. It's already a permitted use.
Thank you. But let me go back to something that you had an interchange with Commissioner Turner the last meeting in April. And you were talking about, why would I need a permit? You were basically, correct me if I'm wrong, okay, you were basically saying their grandfather, they don't need to get a permit.
Right.
And then you had an interchange and you said, what would I need a permit for?
Right.
Okay. Well, flashback into my head, Mr. Higley had an oil tank there, or a diesel tank, whatever it was.
Right.
And he was running some kind of a business there with diesel equipment, construction equipment, whatever. I only saw pictures. And he bumped into it. That's hazardous waste. That can cause damage to all kinds of things. And so to answer your question about a permit, that's one reason. If he had gone to the P&Z or gone to these folks and asked a question about that, I'm sure there would have been conditions on whatever the site plan was and all kinds of things that would ensure the safety, which is one of our purposes
But
here.
if the use, look, that's a different circumstance. But let me ask the town staff. Were they aware of this spill when it happened? Were you made aware of it? Did anyone issue a cease and desist order saying, wait a minute, what are you even doing over there?
I think we found out because some people registered a complaint.
Right.
And they
But
told
this-
us about it happening.
Yeah, fine, but I'm saying this thing's been going on for at least 80 or 90 years.
That doesn't
Everyone-
make it right.
But
There's no
Has-
record of that, by the way, the oil tank spillage.
Oh,
you say-
okay, fine.
say
There's
that?
no record.
There's no record. If it happened, there was no record whether.
Well, first of all, the oil tank would have been approved if he got it approved by the fire marshal.
Not if you're telling me he didn't let anyone know he was running his business from there.
I
If
don't-
I go back to what you
It's
just
well known
said-
in the neighborhood. How many
I
times have
know.
people said about Mr. Higley?
That's the thing. I understand that 50 pages tells me that everybody drove by it on Raffia Road over and over again.
And
they
saw activity.
They saw activity.
Right.
The public at large doesn't know if it's legit or not. They just know they're there. So I get it.
Yeah.
I mean, I've driven by it a bunch of times.
Yeah.
I don't even pay attention. At one time, I think we actually looked at the property to buy it.
Okay.
Okay, so I was going somewhere with that.
Take a pause and you can. But if we can go back to the permit issue here.
Sure.
We learn an awful lot. I mean, I certainly watched enough P and Z meetings in terms of when people bring up things and have site plans and talk about the different things that they have to deal with, and they tend to address them before they even walk into the meeting. And they end up being conditions on it. Now, the purpose of all the regulations and those meetings and these people on the commission is to really keep the people and the community safe, because we know about it, we put in safeguards, and we handle it.
Sure.
It's a reason why we have it. So to answer your question of why do we need a permit?
No,
Case
no,
in
I
point.
was saying we don't need it. I'm not, if I make changes to an existing site plan, I need to get a new site plan drawn, okay? This is exactly the way it was for 80 years. Nothing's changed. The building hasn't enlarged. The only work that was done is some interior electric work. The land hasn't changed. It's exactly what you would have seen, except there's a few more houses around it. If you drove by it 80 years ago or 90 years ago, you would have seen the exact same thing. So unless I'm making a change, I don't need any type of zoning permit.
Well, my question would be, and don't take offense at this, but how would you know that? I wasn't around then. I don't know how many vehicles or whatever they had there. I don't know what they were storing there, because I don't know if anybody that's ever been in that building.
With all due respect, if we're going to
just
go
don't
on
know.
the knowledge of you folks, then I can only go back, I don't know.
79,
How much?
1979.
I know, that's when you were born. No, I'm saying, but we had this discussion at the beginning. Other than the letters, which are substantial evidence in the record, all right? Do you have anybody that's told you they went by there in 1960 and there was nothing there?
I have a
Or
question.
59 or 60 or whatever? No. All the evidence points to a fact that there was something there and the property was being used for non-residential purposes. There is no counter evidence whatsoever. So from that, you can certainly make a finding that the use was known in the area. It's been going on for some period of time when it was valid, all right, and that the law of nonconforming uses says, as long as I don't change the use,
So
I don't need any other approvals. You can't make me get a permit for it. You can't make me get a zoning permit or a special permit or what have you. As long as I'm engaged in the same type of use, that's it.
Mr. Rochelle, you look like you have a response there.
Well, I just want to refer back, there's been several, or at least two sections, copies of regulations that have been given to you from 1955 and then 1925. If you look at those, that property was residential, but it was, as far as I can see, taxed and used and considered farm property. And when the Schneiders had it, he used it to make some farm equipment. So if you look in the regulations from 1955 for residential zones, accessory uses and structures customarily incident to any use permitted herein, provided
I
that
need to
such...
get with you. What section?
It is on page 9 of the 1955 regulations.
Which number?
My page 9 or page 9?
Page
The
9.
book's page 9,
Books,
correct?
page 9.
Item number,
13,
thank you. Accessory uses.
accessory uses, so if you look down through there, to any use permitted herein, provided there such accessory uses shall not include any activity commonly conducted for gain except farming. Now, a lot of times with farming, there are accessory uses, and Mr. Schneider's use of that property, because it was farm property to make farm equipment, That's possibly what took place. This isn't farm equipment that we're talking about in this situation. And, I'm sorry, go ahead.
Well, I'm sorry, I interrupted you.
Right, so the original use, which we all agree, Mr. Schneider who owned the property, used it for farming, AKA farm equipment.
He made farm
Where-
equipment, and it was zoned residential, and it was a farm.
Right. Where things get the next step is when these construction businesses did not register with town. They kind of used it as a depot and, right?
Well, there wasn't any mention, going back to when it was subdivided in,
Yes, the 90s.
yeah, so it was strictly residential. Everything pertains to it being residential.
And
And I don't know why. I don't have an answer for anyone as to why somebody didn't address the issue of anything other than it being a residential lot. Nobody mentioned or brought up the issue of any construction equipment, which I don't know if there was or not. I don't know personally, and I can't find the record of that in the town's records that it was being used as such. There's, according to Attorney Landolina and documents that he has, he's got letters from people saying that it was as they drove by and who lived in town. But there's nothing to verify that from anything else that I can find, on record anyways.
But wasn't the last time you're here, you talked to us about what was going, or I believe the applicant did, that it's not construction that was going on behind those bays. There's numerous bays, and they were being used by numerous types of business, not construction.
No, there's 3 bays, and I think what he testified to was there was 2 concrete contractors there.
I thought it was landscaping.
Landscape.
I think he might have mentioned that, but that might have been, there was one gentleman who's no longer there who, the inception of this was somebody didn't get along with one of the neighbors. That's when the neighbor started complaining. I believe that gentleman's gone, but Mr. Rafi's not here, so I don't know. Maybe the gentleman next door will give you more information on that.
During-
But Guimond was a concrete contractor. That's what
Right.
the map said.
I understand.
You know, and first of all,
But Mr. Raffi also said during it, when he chatted with us, that the reason he bought this property is he wanted to rent those bays
right,
so that he had an income stream.
Right.
To whatever type business he could find to put in there.
correct. So if you think that there are specific.
So what you said to me was consistent use of one type.
Yeah, so if you want to say, look, this is a non-conforming use for these types of businesses and for no other, that's something you could probably do. All I'm suggesting is, and again, with all due respect to Mr. Rochelli, he's testifying about something he has no firsthand knowledge of, to say this was only used for farm equipment.
You
The letters-
told us that.
The letters, yes, there was one person who bought a tractor or a setter there, but the letters say there was more going on with Mr. Schneider, I believe. You know, if you look at the letters, they're more than
Says
that.
custom farm equipment, Mr. Landolino. Let's not get down in the weeds here.
This is all about getting in the weeds, with all due respect.
You're respecting me to death here.
Well, that's better than,
The other things?
yes.
Yeah. But what's coming out of this repeatedly is, yes, Mr. Schneider used it for farm on a farm, built farm equipment, and then from there, it turned over to a few businesses that were in construction, which did not file at the town to let them know they were doing it, other than the fact that everybody drove by it every day and saw that they had trucks there and whatever. And now the property is being resold to a new owner, the new applicant, and he wants to use those bays for whatever comes down the street that he can rent them for.
But you can tell them no, because it's a non-conforming use of X, Y, and Z.
Thank you.
But let's go to number 4 in the packet I gave you, page number 4. This is the great-granddaughter of Mr. Schneider. The property has always been a construction site. It doesn't say farm equipment.
And
Okay?
again, this woman would not know that for a fact. That's her opinion.
How is it an opinion? It's a fact.
She doesn't know. We know from the documents in front of us, it was a farm. You showed it to us yourself repeatedly.
But the business,
The business
if there was farming
made
going,
farm
has not,
equipment on it. You said it. You
Yeah.
brought it to us.
in addition to other things.
Okay.
I guess we're going around here. We're not going to get
No,
anywhere
I'm
on this
hearing
point.
what you're telling me.
Yep.
Mr. Chairman? Oh, never mind. Go ahead.
So with all due respect,
Okay,
everything you just heard from
excuse me.
Mr., I don't want to be
Excuse me,
Vinny
I
from.
I think staff was looking to respond.
Okay.
So,
Lori?
you know, I'm reading through this. I've read through it a little bit, a lot of this before, but mostly the last couple days, Friday and today. What I see is that there was a pole barn. It was probably started as just a farming use. You store your tractor, your backhoe, or whatever, which can be construed as construction equipment. And I think that's part of the problem here. It's just because somebody drives by and says, oh, it was a construction yard. Well, was it really a construction yard, or were they storing equipment for farms? Or were they just storing equipment? So that's where you start getting into the business of, you know, contractor storage yard or a construction yard, and what we call it is contractor storage yard. That can also entail storage of rocks and mulch and things of that nature. So, you know, I think, you know, at what point did we start getting the storage of stockpiled materials? Custom farm equipment is a machinery operation, not a contractor's operation. And as Rick had alluded to, it's kind of farm related. I know a lot of farmers that actually fix, you know, their own equipment and say, hey, Joe Farmer, come on over, I'll fix that for you too. And that's how they kind of operate. So, I mean, it seems to me that there's a really big misunderstanding as to what construction equipment is, because it can be both. Attorney Landolino did comment that the taxes are irrelevant, whether they're paid or not, and I think that similarly, there's the lack of a complaint does not make it a legal use. So, I believe now there's 3 bays. I don't know whether that was an expansion of construction, or whether just the one pole barn was made into 3 bays rather than 1. That I don't have an answer for.
Right, I was looking at the pictures, and originally the pole barn went straight in, and then when you went over now, they've got the bays on the side. So something changed, but
Okay. Commissioner Stroni, you have a question?
Yeah, a couple of things. I'm still stuck as well, along with Commissioner Turner. You know, even if, and I'm not saying I am, but even if we said that construction has been there forever, this has since expanded into much more non-conforming use with the rental of bays and leveraging it for an income opportunity by the owner.
How so?
If to your argument, the original use was construction.
For income.
By bringing in, no, you can't go that far, sir.
Wait, people operate a business for no income?
No, sir. If the original, to your point, the 39 pages, is that there's been construction there forever, by bringing in other businesses, you're now changing the types of businesses that operate on that property.
Well, that's different than whether it's rented, or are you saying that there's a difference between being rented for income as opposed to operating a
I'm
business?
not really
on it?
worried about the income side. I'm worried about the use of the property.
Okay.
Right? That's the scope of this board.
Right.
The use of the property has become more non-conforming by bringing in other businesses to utilize that property as well, assuming I agree with your contention that it's been construction forever. Again, it's different when an individual owns the property, is using it for their purpose, i.e., in this case, construction, versus extending it to other business uses. An office building, to your example, is meant to have businesses renting office space.
Right.
You can't argue that. This property, to your contention, 39 pages, has been construction by an individual, generally the owner of that property.
Construction type uses, correct.
Construction type uses by
Right.
the owner of the property. All of your commentary talks about the owners using it for their own purpose
Right.
from construction. Again, this is just where I'm evaluating, sir. I would argue that as the land has been developed into residential around it, the land has changed. And therefore, there's a higher responsibility for those aspects to protect the local landowners, homeowners. And while you've contained the nonconformity to what's now, Lot 4, the land has
Smaller.
changed over
The
time.
nonconforming area has gotten much smaller. It
As a
used-
percentage, it's gotten larger.
How
The
so?
the nonconformity is now located in one lot, which is a lot smaller than the original lot that it was nonconforming, as a percentage of acreage.
Okay.
So it's becoming more nonconforming by selling off those lots. My point here is that the land has changed over time.
Yep.
You have homes around it, to which whoever owns the land should make sure that they're doing the right things to protect the local landowners as part of operating whatever business they might have there, construction, farming, or whatever. And again, I just see that the land use has changed over time.
Well, there's a difference between, first of all, the issue of whether it's used as a source of income by someone operating a business there who owns it is not, the fact that it might be leased doesn't matter. If I have an office building that I own and I use it, and all of a sudden I don't need it, I don't need 10,000 square feet, and I lease 5,000 square feet, if that's a non-conforming, it doesn't matter. So that part of it, and I think you backed off of that, I think, but I just want to
Not
make.
worried about the income side.
Okay, fine.
Worried about the
So,
expansion of use
yes.
side.
So if you're to find that this is a non-conforming use, as I said 3 or 4 other times, you can say that this is just the non-conforming use. So you can't change it from, let's say it's a non-conforming barber shop, and then bring like some other type of use in there. So I agree with you there. I don't know that I would agree that a concrete, a contracting business which does concrete work would be any real different use than what had been going on there for the number of years. So I would disagree with you there.
What type of construction was there before?
Well, you had Guimond, who's a concrete contractor. He was, I think, immediately after Mr. Schneider, who apparently worked on farm equipment, had a construction site there, according to one of the letters. So something in that vein. I don't know. That's you're going to have to figure that out.
And we would if they had registered a business on that property.
You're getting hung up on that, and
I
I
am,
gotta say-
because what I'm worried about, and
Yeah.
you know from ZBA, that we have very little that we can condition. And
Well, I'm not asking you for conditions. I'm saying if you say this is a non-conforming use and the use is X, Y, and Z, I think that's within your authority. Okay? That's
And
what I
if-
think is in your authority.
And would you then agree that if I said that X, Y, and Z, that whoever and whatever came there would have to register with the town?
Well,
and then
that's
they
a
would
different-
have to go through the process.
That's a different-
And that's a different problem. And
Right.
the thing is it's like what, making a pretzel. You're twisting it, and I'm not sure how we're going to fix it.
Yeah. I'm just presenting you what was said. But before I,
Yeah.
I lost my train of thought as well.
Been
Oh,
there.
but Mr. Stroney, what you're forgetting in all this, and I won't use my patented, because I apparently get called out on that, all due respect, is the property rights of the person who owns it. What about his property rights? He has vested rights to use it like it's been used for the last 80 years.
Farm equipment.
And you're saying that he now has to change how those vested rights to protect the neighbors? No, they came to him. He didn't come to them. All those houses were built.
I did not comment on him having to change what has been done there
But
before.
you say he-
What I'm doing is highlighting that what's being done there now, the multitude number of businesses and different types, is very different than what you contend as construction business, which is
Yes.
still not necessarily been confirmed as having not been farm equipment.
Well, again, I point to the letter number 4. But
I understand that.
But look, you're going to have to decide the use. But the fact that it's being used by, let's say, 3 operations, if it's in the same building on the same lot, did you read the town attorney's opinion?
I did.
Okay. I think she made it pretty clear without coming right out and saying, how would this have expanded? There's a case right on point that she gave you that said, the fact that we had 3 trucks out there before, and now we've got many more than 3, the courts have held that to be a proper intensification rather than an expansion of the use, and that's the,
No, we've got it. We've got that back.
yeah.
She also quotes, though, and I may be misreading this, I am not an attorney, Zacks versus Zoning Board of Appeals, 218 Connecticut, 324, 332, 1991. Item number 3 was any substantial difference in effect upon the neighborhood resulting from differences in activities conducted on the property. So the activities on the property are something that we have to look at for Zoning Board of Appeals.
I agree with
And
you.
that's what I'm trying to clarify with
Yeah,
you
I agree
and
with
understand your perspective. Okay.
So that's one of the things you can't just say it's a non-conforming use for all non-residential purposes. That would be, the record doesn't reflect that. So you could say it's a non-conforming use for these particular uses,
I don't see it quite.
or similar uses.
Excuse me, I don't quite see it that way, but we can debate that after. I believe at the last meeting, you talked about there being different kinds of businesses, okay? It was either you or maybe Commissioner Turner, in terms of, and we probably have to look at them differently. My recollection of your comments had to do with the construction piece of it. There was a similar thing, it was done by the owners, Guimon and so on, if they had a concrete construction. That was a consistency that went through that. It may also have been why people didn't see it all the time either, I think. But the second thing is that if you're going through to, and it's not an issue with renters, it's an issue with people using it, whoever they are. It could be a new owner. And the change is happening. Now, I'll go back to, I think it's Mr. Herndon, if I'm not mistaken, the pictures that I saw in there from 2022 to 2023 that showed a picture of the property. It showed all Sandy's parking lot there and stuff like that, and not that many trucks. I'm not as worried about the trucks. I am worried about the millings, the asphalt millings, I believe that's the correct term. There's a hardtop parking lot out there. That's what it looked like to me. The second thing, and we'd have to go check it out, that he intimated that they were sitting over what the GIS is saying are wetlands, okay? That's a problem, okay?
Not for you, it's not, with all due respect. I'm using it again. It's not a problem for you. That may be an enforcement issue that's other. What we have here today is a simple question. That this property, according to the zoning enforcement officer, should be used only as a residential piece of property because it's in a residential zone. And he can't find any evidence suggest that it was ever used for anything other than that. And I'm saying, here's the evidence. That's the question before you. If there's a zoning, other zoning violation because it's being used for storage of something that wouldn't be allowed in a contractor's yard or whatever you find the non-conform, that's a different question. If it's sitting on wetlands and someone's violating the wetlands, that's another question for wetlands. That has nothing, the simple question before you is he correct by saying this should not be used for any other uses than residential uses because it's in a residential zone? And my answer is no. The evidence suggests that it's a non-conforming, non-residential use as a contractor's yard, construction yard, whatever you want to call it.
But we also have, we actually do have a complaint in there about both
Okay.
of the items that I made up. And we're actually looking at those. One of the reasons we're meeting is because they have filed a complaint. And we have a petition, as we have some petitions from other people, that as to the issues that are involved there. And they're complaining specifically about what's happening to that piece of property. Things have changed on it. There's soil being dumped. I don't know what's in it. I haven't gone out and looked at it.
Why
I
are
go
you
by
even
it.
asking about that with all due respect? I'm going to keep saying that because I don't
Because
want to
we have-
insult anybody, but that's not part of your jurisdiction. That's not part of the question today. That's not what you're here to talk about.
We can't-
You're going way off on tangent.
We can't talk about an expansion? Isn't that kind of, wouldn't you look at that as an expansion of this, the companies
I
that
don't know,
are in there?
because
Somebody's doing it in
That's
there.
not part of the cease and desist order. We're here on a very narrow issue. The cease and desist order says you're operating in a business in a residential zone, essentially, to paraphrase, and you shouldn't be doing that. And I'm telling you, no. This property is a non-conforming business use, however you want to label it, okay, that goes back, and at the time of its inception, it wasn't regulated, and that therefore, whatever you find the use is, all right, can still go on. Now, if there's been an expansion of that, because instead of a contractor's yard, it's being used for something else, that's a different issue. That has no bearing on what you're here to decide today. And you shouldn't be getting caught up in that, frankly.
Well, I certainly respect your comments. I disagree with them, and we can argue about it another time.
Okay.
At this point, I think that looking at what, as you saw in the lawyers, our attorney's response, is that she questioned that. If, for instance, if we were to look at this as a non whatever lot here, and that basically then we could look at that next question, which talked about expansion. And I think that makes it legitimate, doesn't it? Depends on how we. It depends on how
and
we.
you could say-
Excuse me. It depends on how we rule factually. Okay. If we rule factually on the first one, excuse me. So I get my note here.
Yeah, right, and then you have to talk about expansion. But let's assume that you say this is an expansion. It doesn't mean it's still not a non-conforming use. It's just that the use that's there now doesn't conform under the rules of nonconformity. And so that the property owner wouldn't lose his vested rights to operate a non-conforming use there. It would just be he's not allowed to dump stuff or whatever, that kind of thing. But it doesn't change the ultimate outcome of the first question.
We'd have to come out and answer that in the affirmative and say it is a non-conforming lot, a non-conforming use.
Use. Right.
Okay? And then the next question just becomes, it just follows right along, and we'd have to respond factually about that as well.
That's your charge, yes.
Yes, it is. Okay?
But, Mr. Chairman,
Yes.
if you follow the attorney's logic, and we're only here for one question, is it a non-conforming use, R33, or commercial use? We wouldn't even be able to speak on the second question because it's not in front of us.
Well, you wouldn't say, okay, look, you've expanded into a different area, therefore you've lost the entire non-conforming use. I guess that's more of my point. In other words, I don't lose my non-conforming status just because it's being used for a different use today, if you make that finding. And the use that it's being used for today doesn't conform under the rules of non-conforming uses. That's up to you. But the threshold question is, again, to respond to Rick's, if you read Rick's cease and desist, it doesn't say about piles of stuff, I don't believe. It just talks about the fact that, in his opinion, this shouldn't be used for any non-residential uses.
Any questions? Mr. Rochelle?
Anything other than the farm associated with the original farm use, then no, nothing else other than what would be allowed in the zoning regulations. There's no records of anything else other than the it being used as farm or being taxed as farms. Like I said before, there's no records of any businesses for that property other than Gumand. And even back then, even if there were going in there, just because it wasn't enforced, I can't speak on why it wasn't enforced or anything else other than it wasn't. And if it was just farm, and when Margaret Dupree owned it for that number of years before Gumand maybe rented it for his use, and then until Bull used it, there's no records or approvals for that.
I'm having the same trouble because I've gone through all the records that I can find or that either one of you folks have shipped to us, and there's so many gaps in there. I can't see that. Nobody can tell me when it became an R33. Maybe an R17 before that, which is with nitpicking if we were going to deal with that about residential. There's nowhere to say that it wasn't farming because it was being taxed as farming. Okay, up until what, 64, if I'm not mistaken. So what was it? And then if we had people using that, we have no records of their use. We have a lot of anecdotal records that we have from folks that it goes back 70, well, won't we even be 70? I don't think anybody's in that age group, but it goes back a long way. But I think there's enough, in my mind, there's enough stuff that goes back to the 50s that speaks more to the fact that it is residential, R33 or
The signed maps that I was able to find were from 1966, 66, when it was signed by the secretary, I think it was Michael Ferguson at the time,
Yeah.
it was zoned R17. And then again, after several revisions, I think in 72, and that map was signed by the Secretary of P&Z, Anthony Spazzarini. And it was never changed in those records or those maps, other than
If you're
R17.
trying to assess facts, okay, those are pretty much, I think, facts here in terms of how long it's gone on. Can we go all the way back to the 25 or 30 or 40s? Because we're not even sure what year the house was built, or the building was built, not even the house. So that's my concern.
Yeah, can I,
Go right ahead.
what about the map that you have in front of you now from 1961?
Well, I'm
What's wrong
looking at
with that
that,
map?
but what's wrong with this map is I absolutely don't know what those two little squares that you circled are. I don't know what, I know it's
Little
a spot on,
What squares? I'm not,
Please let it,
yeah,
it's a spot on the map
Yeah.
on Raffia Road
yeah.
that we can only assume is that area. I don't know if it's the farmhouse or if you're trying to persuade me that it's the shed. These two little squares don't tell me what I'm looking at.
It's 110 Raffia Road is what you're looking at.
And nowhere on here does that say 110 Raffia Road.
Right, can I approach?
yes.
I understand what you're telling me, and I can.
It doesn't pick out any property. Show me one property that you can identify by the fact that there's a designation of a street.
And you're
That's how
right.
zoning maps work.
Right. And where, whose map is this?
This came from the town, out of when I said, give me the
Okay.
file of zoning maps.
All right, we gotta.
And that was in there. All right, do you have the GIS map?
Oh, I'm sure.
Mr. Chairman, I do want to attest that I am the one that copied that map for Attorney Landolina.
What is that map?
The zoning map.
It's a zoning map
Take a
from.
seat because we can't have you talking at us, and they can't.
Attorney Lynn, if you
I'm
want
sorry.
to, if you want to take this back with you, you can, if you want to look at it.
You want to look at the other one?
We got the other one over here. Okay, so we'll,
So all zoning maps are they just show parcels, they don't show addresses, and we have to, we'll look on the GIS and figure it out and look at the subdivisions, and, I mean, that's the only way you can figure it out. You just have to, literally, it's 4
But
lots
would-
north of this intersection, and
So are
Scale
those
it.
two, that circle that they put in this map, that's just the parcel itself?
Right.
Two little squares. Is it the property that they subdivided into the multiple housing units, which it wasn't at the time, because that didn't happen till the 90s? Is it the farmhouse that was still sitting there and just that, and that became the business because that's where the farmer lived? Or is it this shed that we're talking about that is now lot number 4?
or is it the 6 point?
so Attorney.
Or is it the 6
Attorney
point?
Landolina would have to answer
I
that,
don't know.
because I just made the copies. I just want to tell you that that's where it came from.
Okay, so do we have the GIS map? Let me see if I have a copy of it.
What is it? Me neither. But I see this. And this says it's a shed on lot 4, which is zoned residential. I don't
Okay.
really know where we're going with this.
Do you have this?
So just for clarification, some maps that we have are not signed, and not necessarily, I don't believe that map is signed. Okay, so we have a lot of different maps up in our office. They span years and years. The only ones, decades, the only ones I could find relevant to this matter were the ones that you have and presented from 61 and then revised in 72 that were actually signed. And both of those, between that period of time, there wasn't any change. It was R17. I have no idea why that one was marked as a business A zone, I believe,
Yep.
as a business A zone or not.
Somebody put it on the map.
But
And
whether or
it's a business record of the town of Enfield. And I ask you, Mr., if I went upstairs and I said, can I see the zoning map current today? Would you point me to a large map that's on the bulletin board behind the counter?
I point you to the GIS and you can look at it.
Isn't there a
Yeah,
map?
there is a map behind
Is
it.
that map signed?
It may not be.
It's not.
It's not signed. That's the official map. So the fact that it's not signed, I think has...
Mr. Chairman?
It's a business record of the town. But let me, you want me to go and show you?
No,
Question on that 1961 map,
Yep.
and I'll direct this just out there. Number one, that little square clearly doesn't represent the entire property, because if you look across the street, to Attorney Landolino's own comment, across the street where the plaza is clearly defined as, I think it was marked as Business A as well, right? We're talking about a minuscule little square that can't possibly represent the entire property. So if we're using that as justification that this was a business area, I think that's a little bit of a push.
No.
The plaza is noted on the ones that are signed as a business zone
Right.
for the plaza itself.
Right, the plaza
not
across
that
the street.
particular property at 110.
Right. Whereas this property, there's just that small square, it doesn't complete the entire lot, as we would expect of a full business property in that scenario. Am I
What
reading
else
that
would
right?
it be that was there in the 60s?
I wasn't born yet, sir. I don't
Okay.
know.
But I'm saying, based upon the evidence, what inference could you make?
Again, it's not representative of the property. There
Okay.
there could have been a stand there.
Mr. Lindell, go ahead with your,
Okay. I don't know if everyone has one of these. It might be part of my application.
yeah. Was that numbered in your application?
It was just, I think, just an attachment. Uh,
So just to add on to what I was saying, I found another one of the papers, which I believe came from your packet. Looks like this. No page number. It just says 90 by 200 was that little square. So whatever was there on the road was 90 by 200.
I don't think that came from me, but
It was in with the other stuff. That was from your packet. I
find the GIS map.
did not find that one.
I thought Marianne had showed me that from her stuff, too. Do you have a copy of the application in your file? Anyone in staff?
He's looking. Sorry, are you looking for the application itself or?
The whole package
or
that
the-
went with it. Yeah,
You may have stapled it.
yeah. It's attached to my application, I believe, right?
And it's got to be in this packet here.
Yeah. So if you have the application packet, it might be like the third page.
I don't have it, for whatever reason, I don't have it.
Part of their application.
Okay.
It's in this one.
In the actual application, the original appeal.
Attorney Landolina, you have it, we all have it.
Okay,
Explain to us the significance of it, because
okay.
okay, if you would, please.
So let's look at this first.
Okay,
You can see behind the property, there's a road called Carriage Drive.
yep.
And there's a little small cul-de-sac called Gutter Lane. And when I'm sure I didn't make a mistake and call it something else, Gutter Lane. On the zoning map, you can see, here it says Cutter. I don't know if that's, is it Gutter or Cutter, but it's next to Surrey Lane, in between that and Stage Road, which Stage Road, okay, you see that? Can you identify that area on the zoning map? Okay. So, if you look at the GIS map, the parcel that's in X, which has kind of got this weird, like, I don't know, tear shape, all right, which is now Lot 4 at 110. The building we're talking about is that rectangular building fairly close to the road. Can you identify it?
I see a rectangle.
Okay.
I don't know if it's the house
No, that's the
or
building.
the shed.
Because that's the only that's the only building on 110. The house is next door at 116. That's the old farmhouse.
Question?
No, there's no 1/6, that's 118.
Or 118, I'm sorry. It goes 108, 110, 118. That's the farmhouse. The rectangular building is the building we're talking about. All right? Shed, whatever you want to call it. Because we referred to that one time in the zoning meeting. You can see now, if we want to get really technical, the scale on this, right? You see on the left the scale? So I'm going to approximate the distance from off the road that the building starts, about 150 or so feet. That, kind of see where I'm going with that? Okay. Let's look at the zoning map. The zoning map is 1 inch equals, I don't know. It's either 800 or 1600. I don't have a ruler, but I'm guessing that it's all right?
The whole,
So that rectangle on the zoning map, I'm going to guesstimate, goes back around 400 feet off of Raffia Road. You know, if you take that first black line in the zoning map index, the scale, this one is actually, that's that little rectangle that is a business A zone. All right? So I don't, I don't have an aerial photograph, but I'm telling you that if you look at the location, its proximity to Gutter Lane, the fact that this building on the GIS is about 150 feet off the road, okay, and that this zone B zone that sticks out of nowhere, in the middle of nowhere, that's on an official zoning map, goes back, is about 200 feet wide, at least 400 or 500 feet deep. That's 110 Raffia Road. I think you can generally, reasonably infer that from the evidence you have in front of you. So in 1961, on this map, an official zoning map of the town of Enfield, this property was not zoned residential, it was zoned something else. So no matter what it was like before 1961 and what it was like after 1961, or when the next map came out in the 70s, where it became R17 and then at some point R33, in 1961, this was a non-residentially zoned piece of property, and there was a building there that was used for commercial purposes. That's what the facts say.
okay, just a question.
Yep.
Considering that, that's in that area there, and it was 1961. Correct, okay. In 1961, the piece of property that was there was, I believe, 6-point-something acres, if I'm not mistaken.
Right.
It was one piece of property. And I don't know what the address was of that property, but it didn't have, it should have only had one house on it, which would have been the farmhouse, if I read it correctly.
I would agree with you. One residential structure.
Yeah. It probably, I think there was a shed, but a small shed, there was or garage or whatever, near the house, or at an angle from the house. But the property wasn't subdivided until 1988 or 89.
Okay.
Okay? And so I'm kind of wondering, is this looking at one property? Or is this looking at one lot on that property, or one building on that property? And the other question I have is, why is it there? And I wasn't around in this area here, but it doesn't make sense that that's the only one of those I see, basically, in this part of the map. Yeah. So I'm.
So the property was zoned in two different zones. Most of it was in an R zone, and a little piece of it, which I infer to be where this building was, and still is, for some reason was zoned differently.
Mr. Michelli, we have other maps that are, I don't care about the signature at this point, I won't debate that, but we have other zoning maps that, is it one 1962? Is it one that's 1958? Am I recollecting that incorrectly? That show, this are zoning maps that show the zoning for that
Showed it
area.
back as residential, I believe. And
Pat, is it 1962 or 1958, or am I wrong? That show residential?
I can't answer that, to be perfectly honest with you. I'm not really sure. I'd have to go through everything to,
The Spazzarini sign map is from 72.
Okay, but there's one, there's.
the one before it is 66.
Was it 66?
66.
And I believe that's when your new regulations, the 25 regulations went through various little sets like that. In 1966, I believe, is when you went through and you changed all your zoning.
Okay. Okay, I'm just trying to piece it together. You're giving us
there's
too
a lot
much
of-
paper.
There's a lot of, we are getting into the weeds, but,
Yeah, I guess in some ways we have to.
we're taking where the information leads us. Now,
Mr. Chairman?
Go ahead.
Oh, sorry.
Yes.
If you could please just speak louder, even if you're just trying to figure out an answer
I'm
between
just trying to
yourselves.
see the maps here and see whether one, I knew
okay.
one was 1966, one was
Okay.
1972. Those were signed, I believe, my bad eyes here, that one was 1958. And I'm just trying to check to see
Yes,
whether.
the CEO did send us a
I
copy of that
believe
one.
those dates, yeah. Okay, thank you.
Okay, I've got that here.
Also, I just want to remind you, just because they're, okay.
I understand. I apologize. I certainly want this to be heard. 72 I have. 1966 I have.
I haven't looked on UConn. I got one here, 1958.
This one?
Mr. Chairman, a question to staff, if I could.
Sure.
Rick, or whoever might know, Business A, because some of the older maps reference that. What was Business A? What did that represent? Was it purely commercial? Was it industrial commercial?
No, it would strictly be small businesses.
Small businesses?
Yeah, as noted in the 1955 regs that you got a copy of.
Yep. Okay. Thank you.
Could I address that question? I don't, if you, You can close this tonight, you do whatever you want, but I implore you not to vote on it tonight. And the reason is, that question is a lot more complicated, and it would take me an hour to explain it to you. And I intended to do that, but, you know, if you want to hear it, but read in the 25 and the 55 versions, which are almost identical, which you have in front of you. Read the uses that are allowed in the industrial zone, and you'll find that there are no permitted uses in the industrial zone. There's a list of uses that are not permitted, that are prohibited. That's what it says, all right? It says the following uses shall not be used in the industrial zone. And it has a long laundry list. It goes on for pages, all right? Then it does not say anything else industrial can be used there. It doesn't say the following uses are permitted there. It has none of that language. So whoever drafted them, it's very bizarrely the way they're drafted. So then if you go back and read the business district, which applies to all business zones, one of the permitted uses, it says the following are permitted, retail, so on and so forth. And then you go to a third section, it says, no uses prohibited in the industrial zone shall be permitted in the business zones. Now, why would you put something like that in there?
Repeat that, please.
Yeah, I'm going to find it and read it to you.
Page 19 on your page 11 of the 1955. You're talking industrial?
Yeah, let's go to the 55 ones. They're the darker ones first. The first page is darker.
What page?
11, I think.
Go to page 11.
These are very convoluted.
It says, in any industrial district as indicated on the building zone map, no building or premises shall be used, and no building or part of a building shall be created which is intended or designed to be used for any of the following uses. And then it has, you know, a long list.
You're talking page 19,
Yeah, your page 19, my page 11.
Yeah.
So all it does is list prohibited uses. And then it goes into height, front yard,
Yeah.
side yard, rear yard, stops. So there's no list of permitted uses, of permitted industrial uses in the industrial zone. It just lists those uses that are prohibited.
Understood, but
Yeah.
the CEO responded that this was marked as a business district.
Right,
based-
we're going to get to that.
So the
Okay.
industrial didn't pertain to this question in this scenario.
It does in a roundabout way, which you got to go back now to my page 10,
Yep.
Rick's page 17.
This is business A, right?
Business District, Section 6. I'm going to start because I assume you're there now.
Attorney Lundino?
Yeah,
I think that this was a business A district, which
Yep.
would have been on page
understood.
15.
We're going to get there too.
Okay, all right.
You got to work backwards
See where you-
with these regulations,
Go ahead.
unfortunately. All right, except as herein specified, buildings and structures in business districts, S, plural, may be used for any purposes permitted in residential and business A districts. So if you can do it in the business A, you can do it in any district. All right? And for any of the following, but no other purposes. 1, retail stores, all right? Offices incidental to where goods are, you can read it. Minor and incidental manufacturing operations necessary in connection with any use herein permitted. And then it talks about 12 employees or having machinery of 30 horsepower or less. So that's a permitted use in the business districts. B, and I don't know why I have another B, but uses permitted in section 5.2, which we're going to talk about in a second. And then 3, the other permitted uses. All right, this is permitted uses in the business district. No use prohibited in a business district shall be permitted in a business A. All right? There's no prohibited uses listed anywhere here. And it says, "And no use prohibited in any industrial district shall be permitted in any business district." And it says no junkyards. So does that mean as long as I have a use that's not prohibited in the industrial zone, I can use it in the business zone? Because there are no permitted uses in the industrial zone. I don't know, that's, you're gonna have to ponder about that.
These are 1950-something regulations which
Correct.
don't count anymore.
They were the ones in effect when this business was put on your zoning map. So they counted then. I know they don't count now. That the whole object of a non-conforming use is to decide what was in effect when we started doing this.
So what are you saying that they allow? They happen in that
Well, I
timeframe?
think you could reasonably infer that meant that any uses that were permitted in the industrial zone, permitted, even though they're not listed, were also permitted in the business district. And then if you read section 5, the same kind of language is there as well. So that's why I'm saying,
What do you think this business is that we're permitting that's not permitted?
I don't know. I'm just reading what the regulations say at a time when your property, my property, was zoned to follow those words in that regulation.
Well, it says you can't have cement.
It does say that?
Yes, it does,
All right,
which might have meant it was illegal.
okay.
We're using your own map, using your own
Well,
squares,
then,
using your own documents you put in front of me.
Yep.
Specifically
well, that's
says.
for you, that's for you to decide, but I'm saying.
Thank you for bringing that to my attention.
Yep, good. So, that's everything I got. That's everything that's out there. Sure.
Yeah, where did you see the no cement?
It's on the, I think it's page 19, well, wait a minute.
Unless it was already, the cement use was already a non-conforming established use, which you can't take away from them.
Wait a minute. What was it, page 19, page?
Page 20 of
Page 20 of the
19, of the
regulations.
1955
Right, page
regulations,
20,
number
halfway
12
down.
on Attorney Landolina's
Gypsum,
handout.
cement, plaster, Paris, manufacture. Right, it's not permitted.
If it's being manufactured on site. But if I'm a cement
It doesn't say that.
contractor-
It just says, or. It doesn't say it had to be. It could have been, don't go there.
You mean if I have a cement truck that's parked there and I go to Ron Carey's and pick up cement, I can't, if I'm, no, so that's,
You're the one who had me read this.
I understand that.
Okay.
But I'm saying, be careful about, you can infer certain things, but
Right, you're helping me trying to infer your way.
because it's the right thing to do and it matches the law.
Well, then,
That's, and I
guess-
don't know what else to say. So unless you have any other questions, I'm going to yield to the public.
Yeah, does the staff have any comments, questions that, or do we have any questions or comments for the staff?
do I need to understand, even though our lawyer gave us the 4 pages of lawyerness, I'm having issues with where we go with this, because we aren't allowed to vote on something that's not in front of us. And the lawyer has implied in his 4-page document that if you say this, then you have to do this. But that's not, if you go by what the attorney is
That-
saying, right?
That was the
Am I going down
recommendation.
the right road, Lori?
I believe so.
And the fact that no one, over the many years in Enfield, didn't react, and maybe they should have, it's sitting in front of us today.
Right. So, we are running out of statutory time to close the hearing, so I don't know whether you would like to request that the hearing remain open if you want more data or.
I don't think
or
there's any
summary-
left.
Or summaries, or if you want to close the hearing, I would suggest you also request the public to have any final comments.
I think give me my time frame that we have left. Because I'm looking at,
We're pretty much done with the
Right.
65 days.
Today's the 63rd day.
I can give you more time if you feel you need to keep the public hearing open. I can't imagine anything new that I can tell you. So,
Let the public speak.
But I suppose if you wanted additional information from the town attorney, you could either do that as a staff report and close the public hearing, or keep it open. That's entirely up to you. So whatever you think you need, because I can give you up to another 65 days to close this public hearing. I don't want to use up another 65 days. I think, I've made the argument that I can make, and
I'm not ready to close the public hearing personally. This is
Yep.
just, and I certainly am not going to close the public hearing without having the public have
Oh,
the
no,
chance to
no.
speak.
You're going to do that tonight, so
Okay, you
you can decide at the end of the evening how you want to handle it. But I'm telling you, whatever you want, I'll give you.
Okay.
Right, so the extensions is offered by the applicant. You cannot require it. So that's why Attorney Landolina is offering this.
I want us to keep going.
We're going to have the public. That's going to happen.
I don't want to, I want to be done.
Are we ready to be done?
Well, let's hear what the public has to say.
We'll ask that question after we do. We're going to open the public part of this. I know we had folks come up and speak at the last meeting. We'll do the same here. If you would like to speak at the hearing, if you would please sign one of the sheets
They
that are
can
on the
just raise
table.
their hand. They don't have to do that here. They can just raise their hand, you call them forward.
Sounds great. We'll make it as quick as we can. Mr. Hurden? Will you come up to the mic, please? Give your name and your address, please, and happy to
I've
have
got
you.
some stuff for you as well. May I hand it out?
Yes.
Stapled and numbered, please.
Stapled and numbered as requested.
Thank you.
Thank you. Well, thanks. Please speak into the microphone.
Okay. I'm Bob Herdman. I reside at 108 Raffia Road with my wife, Amy. I'd like to wish her a happy 19th wedding anniversary tonight. So I neglected to leave myself a set. I apologize. So I'll be brief. The first set of maps, there's 4 maps here. They're renderings based upon the maps that were already filed as part of the original packet from the April meeting. If you go through them, you can see in 1940, there was the one residential building at 118 Raffia Road, and then there's the brown building, which is the structure in question tonight. If you go to the 1988 filing, you can see that Lot 1 is the existing farmhouse. Lots 2 and 3 are to the south of it. Lots 4, 5, and 6 were established in 1988, and you can see that the building in question straddles Lot 4 and what is now part of Lot 1 to the rear. And then if we go to the 92 filing, what you can see is the 2 lots 7 and 8 to the rear were built. And what this establishes, obviously, is that this once 6-acre parcel was in 1988, beginning in 1988, subdivided to become a residential neighborhood, as many farms in Enfield, as I understand it, have over time. And I respectfully request that that residential neighborhood, that residential subdivision, be preserved and protected by upholding the cease and desist order on the pole shed. It's my understanding in speaking to the neighbors that Mr. Bull, when he filed these permits, fully intended to build on Lot 4, intended to tear down the shed and build on Lot 4. And that's supported by, if we go to drawing number 4, when he separates Lot 1 from any part of the structure with Lot 4, and Lot 4 becomes a separate building lot that he intended to tear down the building and put up a house. Unfortunately, he fell ill, and his sons never followed through with that plan. They instead, in 2013, decided to sell what is now Lot 4 on that map. My wife and I bought our house in 2006. When we purchased our home, there was no construction activity. There was no activity at all over there. In fact, as I understand it, in speaking with the neighbors, there was no activity on that piece of land from 1988 forward. And in all of the supporting letters and information that Mr. Landolina provided earlier in his packet, all of those testimonies all spoke to things that happened long before 1988, when this parcel was subdivided into a residential parcel. So I understand that there's history to this land other than residential potentially, but in 1988, this became a residential neighborhood, as did many farms in the town of Enfield. And I think it perhaps is a dangerous precedent to state that somebody could go back to one of those former uses after that residential neighborhood has been established.
What house number are you?
We're 108, we're the next lot, we're denoted here as Lot 5. So, and then the second piece that I handed everyone is a picture, satellite image of the 2022 Google Maps satellite image, and then the 2023 picture is something I took with a drone to match the satellite imagery. And you can see that the commercial look to this parcel has changed considerably just in the last year. So 1988, it became a residential parcel, or at least was applied for a residential neighborhood. That was 35 years ago. Mr. Raffia didn't buy this property until 10 years ago. So for 25 years, this was quiet, not a commercial application, residential neighborhood. And I appreciate that there are many in town that remember when this had other applications. But for those of us who have purchased homes in the area subsequent to that, I respectfully request that the cease and desist be upheld and that this be considered residential, as all of the filings for bulk construction consistently demonstrated over time. So, thank you.
Thank you very much. Anybody else would like to speak before the commission? Just raise your hand, please. Anyone else for a second time would like to come and speak before the commission? Please raise your hand. For a third time, anyone who would like to speak before the commission, please come up to the mic. I declare the audience part of the public's part of this meeting closed.
Mr. Landolini, that's not, the public hearing is not closed yet.
Just the audience part.
No.
Oh,
Hearing
correct.
is not closed.
Mr. Landolina, do you have anything you'd like to?
I do, Mr. Chairman. Thank you again for the record, Carl Landolina. So to boil this down, I think, to the simplest thing, first of all, with respect to Mr. Herndon's comments, here's another piece of evidence that the complaining party gave you that shows the building in 1940 located on this property. So you may think it's anecdotal, but it's the best evidence. And under the law, you use the best evidence you have, and it's substantial evidence for this type of proceeding. All right, I wish I could show you a drone picture of the property in 1920. I can't. So we're left with what we have. So we've got the complaining party admitting, with documents on the record, that this building was there around 1940. Our information traces it back a little earlier than that. What else do we have on the record? The earliest zoning map that you have in your possession that shows this property, I believe, is 1958. So you do have zoning ordinances which go back before then, but there are no maps. And the zoning ordinances say in the beginning that the zones that are applied, the residential, the business, the industrial zones, are as shown on the zoning map. So without evidence of there being a zoning map showing this property until 1958, what inference can you draw? Zoning didn't apply to that property before 1958? I don't know. But there's no evidence to say it did. The earliest zoning map you have is in the 20s, and it only showed the downtown areas, Hazardville, and so perhaps a reasonable inference could be that until a zoning map was produced showing this property, it had no zoning designation. It wasn't shown on any zoning map. And therefore, any use that started before it first showed up on a zoning map would be legal at its inception because it wasn't zoned anything. It was a practical, in other words, if somebody had built something in 1910, you would certainly say, whatever it was used for, and there's plenty of buildings out there around Enfield that were built way before 1910, they weren't zoned because zoning didn't exist. In 1925, zoning started to exist with the adoption of your zoning regulations. But according to the information you have in front of you, is what you have to go on, is that this property the zoning regulations didn't apply to this property because it wasn't shown on the zoning map.
What year?
1958, that's the earliest map you have. So we know the building was there before 1958. We know it had uses. You've got letters as to what those uses were. All right? So a reasonable inference could be that until the zoning map of 1958, any use that was put to this property, as long as it wasn't abandoned and met the other criteria for non-conforming use, was a use that this property, the use of the property became a vested right for the property owner because it existed prior to the zoning applying to this property. I knew that a residential neighborhood grew up around this property. Those houses came to this property. This building existed before those houses did. It has, according to the complaining party, I don't know if this is a quote, but he said it had a history, even though it had a history of non-residential use. Another thing we agree on, it did have a history of non-conforming use. But apparently there was some time, I think he said it was like 25 years, it was quiet. Well, the law of non-conforming uses, as given to you in the opinion by the town attorney, and as reflected in the statutes, means unless the owner says, I'm going to abandon the use, it doesn't go away. It may have been quiet, and maybe it's unfortunate that it was quiet during a time when people were buying houses in that area, but the non-conforming use, the vested right of the current property owner existed, and it can't be taken away from him. Now, what that right is, what that vested right is, you can look through the records and you'll have to determine it for yourself what it was. The maps don't lie. Mr. Herndon is correct. It went through some changes. Now, if those changes don't meet the zoning that's allowed there, i.e., whatever it was in 1958, when the zoning maps first came out, that's a different issue. If the zoning enforcement officer issues a cease and desist and said, you put down blacktop without a site plan, you're going to need a site plan, that's a different issue. He'll have to comply, or he'll have to tear it up. That's a totally different thing. But the law and nature of non-conforming uses doesn't change just because houses were built around it. And I don't know, when Mr. Bull owned the property, maybe he did intend to do that, but it didn't get done for whatever reason. All right? I know his sons continued on in the business. For whatever reason, they decided not to tear it down. And it's still there. It's still being used for non-residential purposes. So I think this respectfully meets all the criteria for non-conforming use. What that use is, I'll leave that to you. You'll have to go through the record and say, if you believe that it meets the criteria of a non-conforming use, you'll have to go through and say, was it farm equipment or was there other stuff going on there? So go through the record, watch. I know Mr. Raffia testified last week. There were a couple other folks that aren't here tonight, so maybe watch the tape from last time and see what those other uses might have been. I know there was talk about welding and stuff, but it's all on tape, so you can watch it. That's part of your job, to tell me okay, it's a non-conforming, non-residential use, but the scope of it is this. That's all well and good. And if we disagree, then, we'll have avenues to pursue. But the fact that it was quiet for 25 years, or maybe somebody was going to build a house there, doesn't matter under the law of non-conforming uses. So that's all I have. Thank you.
The public speak again.
Chairman Turner, please.
You need to get going.
Thank you very much.
Okay.
If there's anybody from the public that would like to speak, please raise your hand. Come on up.
Bob Herman, 108 Raffia Road again. The way Bull Construction subdivided Lot 4 away from the main parcel is consistent with their wanting to build a house there. The intent was clearly expressed in the repeated filings of subdividing toward building lots. So Mr. Landolino wants intent and abandonment. It's there in the plans that Bull Construction filed long prior to Mr. Raffia owning the land. And it's the succession of those building subdivision plans clearly shows that this was intended to become a residential lot. So, and Mr. Bull did state that to multiple neighbors at the time. And then unfortunately fell ill, and his sons never followed through with those plans. However, the intent was there. Thank you.
Thank you very much. Is there anybody else that would like to speak before the commission? Is there anybody else who would like to speak before the commission for a second time? Come on up. Give your name and address, please.
Justin DeLeo, 7 Harrison Ave, not even here for this one. You're talking about non-conformism, right? But your client is now, the client, from what I've heard, is now renting out this property, meaning that it is not the same type of business that people who was there before and actually using this as their own property and storing their own stuff or doing their own business there. Now you've created a whole different type of business that is renting out to multiple other businesses, changing the whole conformity of what it was there to begin with. And as I said, I'm not even here for this one, and I just kind of picked up on that. It doesn't sound like it's the same type of thing. They might be doing the same type of activity, but the owner has changed the business of what is going on.
Thank you. Is there anybody else in the audience that would like to come up and speak before the commission? Second time? Anybody wants to come up, speak before the commission? And third and final time? Anybody would like to come up? Just come on up. Thank you.
I make a motion to close public hearing.
I always get the last word,
Can't have you not get that. Come on up.
And I can trade back and forth as Mr. Herndon if he wants to go all night, but I won't talk about what he said because I explained that to you before, and I'll explain again to the gentleman who just came up here. He's finished off with the activity might be the same. That's the whole crux of this issue. Not whether it's being leased out, whether there's two people renting or one guy, whatever, owning. The activity. Is the activity the same? And that last gentleman said the activity may still be the same, but now since it's being rented out as an income-producing property, well, all business property is an income-producing property. So
Mr. Landolina, I
Yep.
don't believe that's what he said.
he finished off by saying that the activity might be the same. So that's what I'm pointing out to you. That's what he said,
We're not
right?
going to have an interchange back here
Yeah.
between the dais. Is there anything else, Mr. Landolino?
No, I guess not. No.
Thank you very much. One more.
Public hearing's not closed yet.
Pardon me?
It's not closed yet.
I'm going to ask the audience if they want to come up. Is there anybody else here that would like to comment for a last time here, for another time? Ask you for a second time. If you'd like to come up, just come up to the microphone. And for a final and third time, if you'd like to come up, please come up right now.
Make a motion to close public hearing?
Second.
Okay? Any discussion? All those in favor, please raise your hand. The public hearing is closed. We have a discussion to take care of right now. It would seem the number one thing that we do have to deal with is to decide whether this is a legal, non-conforming use.
So, through the staff, through the chair, I noticed that it's 2001 when they redid Lot 1 and 4. Do we have the minutes for those? I can't find them in my piles of paper. Wait, I found 1992, but not 2001.
I don't think they're there.
I don't believe I looked for or found the minutes of those meetings.
What's that? I think it might be on the back page of one of those other things, because that's where I found it.
I remember reading those.
It's too much paper. I think I showed it to you before.
Let's have the 92 stuff.
Say it again.
92.
It's on the back side of that, right?
Right, but it's all 92.
Is it?
Yeah, it's just 92. I could not find the 2001. I just found the Secretary of State 2001. That was all I found.
I can't find it, but,
Do you want to know why I'm hung up on that one?
pardon me?
I said, do you want to know why I'm hung up? I was just looking for what the minutes said on the intent of it being subdivided. Because
I know what you mean. There was a blurb this far that defined and talked about the subdivision in 2001.
And the reason that I'm asking is, so on I'm stuck on the abandonment and the legal non-conforming, and that was why I was looking to see what the minutes were and what. I know people have said what the intent was, but I just want to see what was actually in the minutes.
Unfortunately, since you've closed the public hearing, we can't give you any more information.
That's fine.
I mean, and if we've given it to you, we can show you where it is, but if we have not, then we
Okay.
can't be giving you any more. Sorry.
Thank you. Anybody else? Anything, Charlie?
No, I think we have a lot of questions that need to be answered.
That's right.
I'd like to see this tabled. But are we allowed to get any more information?
No, because we closed.
Because we closed the hearing.
You could ask staff to clarify some issues or something like that, but we just cannot give you additional information. So. And you don't have to act on this.
To the director. ZBA's rules. If we look at the nonconformity, can we then add conditions or whatever the right nomenclature should be, that it would have to be in full compliance?
I think what you can do is clarify, if you decide that there is a nonconformity, you need to clarify what that is. And then you can, and then it would continue from there.
I-
You're not
Basically, we have
supposed
to make a factual decision about whether it is or whether it isn't.
Right.
If we decide that it is, then we have to, then we have a choice of looking at
That is
some
true.
other issues.
Yeah.
Mr. Chairman,
Yes.
we can go through all this paperwork, and we will find that maybe, no, during the time of 1950 forward, this property was used for a variety of things. Was it non-conforming? Yeah, I'd say, my opinion, yes, there was a nonconformity done, and maybe people back in time turned a blind eye to it, which then let the nonconformity continue down a path. But being nonconformed does not mean we make it more nonconformed or we don't make it come into compliance. So we might agree that yes, that the original farm equipment builder, and it was a farm, did some type of manufacturing on that property. And then as time moved on, they did these other businesses, and again, not being here at the time, maybe the commission turned a blind eye and allowed it. That doesn't make it right. The attorney has shown with his numerous documents that yes, something was going on that property. No ifs, that's clear as day. The town has said, and they've proven their side, if that's the right language, that this is a R33 zone and farm. Those both are intertwined. But what it's not is business local, business general, industrial use, or any of those things. We have no businesses other than the one construction company that filed that they actually ran their business from this property. But anyone that bought it further never filed as a business on this property. They just used it. And the nonconformity kind of dug its fingernails in. That makes any sense? I won't disagree that that's there. What I have a issue with is that we need to bring it into uniformity with the rules that surround the property today. And that means whatever happens needs to be in compliance. And I am saying that we need to be clear as we move forward. I don't know how the other commissioners feel, but I think that we have to fix this once and for all. Keep in mind, whatever this board now does, because we are the first ones who are given the opportunity to actually speak on this property, it will be forever. What happened in the past, no one took that opportunity.
Anybody else? Yes.
Just referring back to from the attorney's opinion here, from the town attorney's opinion, I quoted Zach's versus Zoning Board of Appeals from the 1991 case. The three questions.
Right.
The extent to which the current use reflects the nature and purpose of the original use. To Commissioner Turner's point, it was a farm before.
Yep.
Yes, there may have been some activity supporting farm repairs or something like that. We don't know, but the presumption is it was farm and used for those purposes. Any differences in the character, nature, and kind of use involved? And I think that's, again, to what Commissioner Turner is saying, it has changed over the years, not from a legitimate perspective, but it has just changed. And then the last question, as I mentioned before, any substantial difference in effect upon the neighborhood resulting from differences in the activities conducted. Those questions, I think, are relevant to our decision. And again, I think it's in line with what, not to put words in your mouth, Commissioner Turner, I think what she's saying there. That this, yes, that we can agree that the barn or that structure was there for a long time. It was used as part of the operations of that property and then has just migrated from there. I'm concerned that there was no official businesses registered on that property, which means someone just used the property for whatever they needed it for as the owners, right or wrong. So.
Anybody else? I have a couple of questions, a couple of comments. I have a hard time dealing with this,
You need to speak into the mic.
excuse me. I have a hard time dealing with this as a legal non-conforming use. That it just doesn't stick, it sticks in my craw. I think it's more, like you just described, Commissioner Stroni, that it kind of just happened. I think Commissioner Turner did something similar to that. And it evolved. And I don't think that, I don't think there was any legal, it's hard for me to put the word legal in front of it. It certainly wasn't a use that fit any of the other zoning rules they have, R33, R17, or whatever. And it certainly wasn't allowed. So in my mind, legal, and it certainly wouldn't be allowed today. And I think in terms of the 3 questions that our attorney had put out, she'd put them out, though, with the prerequisite that we had to vote that it was a non-conforming lot. Then we could address those issues. That's how I read it, unless you read it differently.
Say what you said again?
I said, when she put these things out, she said we had to answer the first question in the positive, that it was a non-conforming use, a legal non-conforming use. I don't think they distinguish it between legal and non-conforming use once we call it an issue of fact. Then we can go into these 3 questions. And if I go through the 3 questions, I've got a question mark for number 1 and a yes for the next 2.
Which 3 questions?
I'm looking at page 4, and it's the middle paragraph.
Comments were made during?
These are the 3 questions that the ZBA should ask in terms of deciding whether the current activity is within the scope of a non-conforming use.
Excuse me, Mr. Chairman, can you show me where you're at? Okay, right here.
And Mr. Chairman, I would agree that if we decide that it is not legally non-conforming,
Yeah.
if I'm saying that right, then we wouldn't even get to those questions. I agree completely with that.
Yeah. Just to further throw into that, in the first question, I'm saying whether that we have to decide whether the current activity is within the scope of a non-conforming use. I don't think it is. I think,
Say it again.
we have to decide whether the current activity, that means what's going on there now, okay, is within the scope of a non-conforming use.
Of what the attorney's trying to say the non-conforming use was.
She's saying back at the beginning, and you said something similar, that what went on in that the window there was could be non-conforming.
Correct.
So we're saying that it is, and I think we all have our questions about that, but we're essentially saying that there's a non-conforming use there,
Right.
for discussion's sake. What's going on now, in the last several years, we have to decide whether that current activity is within the scope of a non-conforming use. I don't think it is. Then we can go on to the next 2 questions, which I think pertains to some of the things you pointed out, Chairman Turner, and you did as well, Rich. So that's how I look at it. Your thoughts,
I think you're hitting the nail on the head.
Rich? Yeah. Your thoughts?
First, we all have to agree if it's the non-conforming, then we go on to the 3 questions.
Correct. So we have to, that we're deciding that making it a non-conforming use is we're making that one of the facts of the case. We're saying, yes, it is.
And just
We're
for
gonna go on.
clarification.
Otherwise, we just, if we say it's not, then it's over.
Point of clarification.
Sure.
We're, in this scenario, we're simply voting to uphold or not uphold the ZEO cease and desist.
Correct.
In the grand scheme of things, correct?
Correct.
Based on our presumptions around what we just talked about.
Right.
Mr. Chairman.
Well, yeah.
Yes.
So the motion, if you look at it, is in the affirmative for the applicant. So if you vote in the affirmative, you're upholding the appeal. If you vote not to, or vote no, you're not upholding the appeal, but rather upholding the cease and desist order.
Say that again.
The motion that you have before you is in the affirmative for Mr. Raffia and for the property. Okay? It's not to uphold my order, but rather to uphold the appeal.
Right.
So if you choose to uphold their appeal, you would vote yay. If you choose to uphold the cease and desist order, then you would vote nay or no in the negative.
Right. And if I might,
Yes.
if you just, I mean, as far as the issues, the more simplistic questions are on page 1 of the town attorney's memo.
The issues?
This page 1 says issues number 1, whether the commercial use of the property is a legal, non-conforming use. If it is, then you would go into, if you decide that it is a legal, non-conforming use, then you could go to number 2, and whether the current commercial use of the property is an illegal expansion, extension, or illegal intensification of the non-conforming commercial use of the property. If you decide that it is not a legal, non-conforming use, then you're done. That's your decision,
Correct.
right? So
But-
it's a little.
But that's the issue, Lori, because it's not like you're going to vote on a question and then vote on a second question. These have to be molded together in your mind on how you're voting on this
That's why
motion.
I brought you to
Right,
those,
'cause it's
because it's a
very-
little bit simpler than the 1, 2, 3 that they have
Sure,
further on
but
page
it
4.
doesn't, I understand, because that's the argument. The illegal expansion, extension of the use. Mr. Chairman,
Let's just, let me just see if there are any other questions for the rest of the commission. Go ahead, Madam Chairman. Commissioner.
do I want to move to motion?
Go ahead.
Like a motion to approve ZBA 2023-1010 of 110 Raffia Road, the appeal of the property owner of the use of the property at 110 Raffia Road as a legal non-conforming use of the property for construction commercial purposes.
Is there-
the motion.
Okay. Is there any discussion?
Now, we're just a vote now. We're just a vote now, correct? Yeah, we did discuss.
You may have a discussion, but
You can have discussion at this point.
Yeah.
Okay,
A
go
motion's
ahead.
been made and
Should you
it's been
desire.
seconded. I just want to clarify,
So we're
go ahead.
only voting if it's a legal non-conforming. Is that what we're doing now, or we're doing the
We're voting,
appeal?
we're voting,
No.
period.
The appeal, okay.
Do we agree? Do this appeal, the way it's written, the applicant has come to us appealing his cease and desist. We're voting on that appeal. Do we agree that they're right, or do we agree that he's right? So go ahead, clarify what?
I'm stuck on those three questions at this point, okay? As I said at the beginning, I don't think it's a legal issue, but that's, makes my decision relatively easy. I'm sorry. The first question is it a legal non-conforming use? Okay? I don't think it is. So let's just, hypothetically, I don't think it is. If I get to vote now, basically, based on that hypothetical response, then I'm voting against the cease and
applicant.
desist.
that would be
applicant.
correct.
Yeah, I'm voting
if that
against the
was your interpretation.
Okay. And the other two questions don't mean anything, except maybe in
Correct.
another venue at some point. Okay? Okay, that clarified it for me.
So, a question to the chair.
Yes.
So if we vote that it's not a legal non-conforming, now he can't even use it for farming purposes?
He can.
He can.
He can use the building. He can't rent the building. They can't do,
You can't do what they're doing.
they can't have businesses there. He can use the building.
He owns it.
It's a pole building. It's an agricultural building. That's what it's being taxed as.
That answer your?
Yes.
Okay. Anybody else? No? Kelly?
I don't think so.
Okay. I don't want to push it. Just, any other questions? Then let's have a roll call vote, please.
Tim Neville,
No.
Mary Ann Turner, no. Kelly Davis,
Yes.
hang on a minute. I need to ask the question again. No upholds the way this is written, agrees that they're right and that the appeal of the property.
If you answer in the affirmative based on the way the motion is written, then you are saying that, yes, it's a legal nonconforming use. If you vote no, you're saying that it's not a legal nonconforming use.
Okay. Charles Masterbirdy,
Yes.
Rich Stroney,
No.
3 noes, 2 yeses, it doesn't pass.
So they didn't have, so basically that doesn't pass because there's not 4 affirmative
We have to have
votes.
4 by statute, yeah.
You were 4. No, you were. You were. a
Can we
yes.
have reasons for that vote, please?
I have no idea yet.
No?
The break, please.
So moved.
Second?
What was that? Oh, to take a break?
Oh, yeah, just for a side view.
Yeah, it should be,
meeting. Madam Secretary, if you could read the legal notice
Sure.
for the next item on our agenda.
ZBA 2023-05-23, no. ZBA 2023-04-27, 90E Elm Street, applicant seeking relief from section 10.30.5, signs in business districts. Raising Cane Chicken Fingers, applicant Enfield Square Realty LLC plus CH LLC and Enfield Nassim LLC, owners map 43, lot 28, BR zone.
Will the applicant please state their name and address for the record?
Good evening. My name is Jeff Board, professional engineer in the state of Connecticut with Bowler Engineering, located at 65 LaSalle Road in West Hartford, Connecticut. Here on behalf of Raising Cane's. With me here tonight is Michelle Robinson from Michelle Robinson Design, representing the applicant as well. Appreciate your patience and look forward to running through this with you guys. Project's located at 90 East Elm Street, as you can see on the screen here. Do you guys have it in front of you now?
Now we do.
Yeah,
You do?
no, we do.
Great. So basically, north is the top of page here, and this was just to orient you guys to where we were at within the grand scheme of things here. Enfield Square Mall is to the south. The Target is right in this location with the Target parking lot to the south. The mobile gas station is just to the west of our site. We're bordered to the north by Elm Street. And there's a jewelry store right on the corner here, and then bordered to the east by Freshwater Boulevard. So we're here before you tonight requesting a variance for a sign on the rear of our building, and that's pursuant to section 10.30.5B.1. And basically what we are asking for is just the location of that sign on the rear property. So as I orient you here, one of the reasons that we're before you is the language in the code basically says for attached signs for each occupant in a building are allowed on any portion of a wall facing a public street. Now, in our case, it's unique in the sense that we are on this internal ring road of the mall parking lot. So it is heavily traveled. It is operating as a ring road to the mall. And there's view corridors even from Freshwater Boulevard where you can see even the sign across Elm Street on the adjacent retail spot over here. So it's unique in that regard. One of the other things that's unique about it is the fact that we are complying from an area standpoint with a lot of the regulations. So we worked closely with town staff over the last month or two, got some feedback early on what we had originally submitted. And let's see if I can scroll here. So there had been some confusion early on as we coordinated with town staff, and they were nice enough to work with us through the process. And we had a few different things located, and on the bottom of the screen here, you could see the rear elevation facing south. That's the one sign. It's 8 feet by 3 foot 10 inches, so 32 square feet. And we originally had multiple signs on this rear wall in way of murals that we were told by town staff not to come forward with. So we went back to the drawing board, came up with this scheme, which by the town interpretation, we're allowed 183 square feet of area. We're now at 173 square feet of area. So we're no longer seeking any sort of area variance as far as that goes. But what we are seeking is, and what we're arguing is that the unique shape of the property in the sense that we do have a ring road, north of the mall between our properties. There's the driveway entrance, and it's hard to see, is right here. And that's the only driveway entrance into the property. So if you are heading north up this ring road and there's no markings on the back side of this building, you could potentially pass this. There's no other way to get back into the site as there's no connection on the driveway entrance or there's no connection along the state highway or frontage. So really that's the only two-way entrance into and out of the site is on that ring road. With that, I know we've gotten our wetlands approval, our planning and zoning approval, and we're working through the Connecticut Department of Transportation for our Office of Traffic Administration approval, which we should be securing here in the next month or so. So with that, I'd be happy to answer any questions that you guys may have for me.
Yeah, you mentioned this 183 square foot max. What was yours? again?
So we were at 172.75.
Thank you.
So it's about 10 square feet less.
Yep. Thank you.
Other questions of the commission?
Can you show me how, sorry.
Okay.
Sorry, I was going to call on Vice Chair Neville.
Okay, I went by there yesterday to just get the lay of the land.
Yep.
And I was just trying to figure exactly where that sign's going to be. It's going to be facing the travel road there.
Correct. So right on this rear, right where the hand is now, that's where the sign is, kind of centered on the site. And when you come into this view, go up this way. So you can kind of see it. It's right where the mouse is right now. So it's kind of halfway between the jeweler and then the entrance drive coming in next to the mobile station there.
Okay. So is that the only sign that's, how many signs do you have in the building?
So there's,
You have it on 3 different walls.
so
as
right
well.
now we have that same sign, that 32 square foot sign shows up on the east elevation, the west elevation, and then the north elevation. And then there's 2 smaller signs. There's this one right here, and they're all identified in that signage chart that we have on the exhibit.
Okay.
So the totality, 1, 2, 3, 4, it looks like 5 signs total.
Okay. Are there signs approaching it that announce your?
So there's a sign right on this corner, so as you're coming in, and that's the ones that are visible from Elm Street would be these 3, which is why those are allowed on the sides.
Yeah.
And then the aggregate area has to be less than that 183 square feet that we're allowed, just based on the linear footage of the building. So what we're arguing, and it's the more conventional sense, and when you have these zoning codes that read, you don't want a sign on something that's not facing a public street, is when you get into the Palumba Drive ones at the Big Y Shopping Center, where you actually have parking up against the rear, or you have an internal drive aisle to a parking lot, which then it makes sense not to have one. There's a lot of other cases, and I think it's, I had written down a few of them, but like Freshwater Commons was one of them, Enfield Commons, Brookside Plaza, the majority of those, and they may predate the current zoning, but all of those retail establishments, restaurant establishments, the majority of them have signage on the ring road, including right across the street at this location here, with exception of 1 or 2 of the new ones that have gone in where they do not have a sign on that back, and they're actually hard to identify.
Okay. And you're within the total amount of square footage
Correct.
of the signs?
We're less
the
than
whole-
10 feet based on the town interpretation.
Yeah.
So yes.
Okay, thank you.
Further questions of the commission?
I'm still confused about the number of signs. I went and read your summary table. There's allowed and there's proposed.
Yep.
So your proposed doesn't fall into your allowed section. You're telling me you want 5 signs, but it's not in the allowed side. So just
Correct. So-
explain your summary to me.
Yeah, so the proposed number, where you look at it, you get 2 square feet per linear foot
Right.
for area. The number that the town had come up with as far as what they were interpreting as our frontage was that 183 square feet allowed. So there's not an actual number requirement or maximum allowable number of signs.
Hey,
What
can
they-
wait 1 second
yeah.
on that. So
Sure.
I'm confused on that, because on the town's information that they gave us, it says the total square footage of proposed signage includes a freestanding sign. You have a freestanding sign?
Correct.
And amounts to 296 square feet.
The freestanding sign?
I-
The freestanding sign's only a 32 square foot face.
Well, I'm just reading what says, I'm interpreting it to mean your total amount of signage is 296 square feet. Is that what you meant, Rick?
You'd have to go to the revisions. That was the first calculations from science. So if you go to the revisions section of the staff report, they are now limited to, I believe, 183 square feet.
Correct.
If you look at this one here, this diagram that's up there, when we count the linear length of the front of the building, which would be to the north, I believe the length of that front of the building is 96.8
Correct.
feet long.
Correct.
They interpret it as a 101. It really bears no meaning on what's before you with the rear signage, but we calculated it different. They took into account the rear portion of the building. We don't do that because it's not the front wall of the building.
Okay.
So that's the only difference. There's a difference of 6 linear feet or 8 linear feet. So it doesn't really impact the square footage for signage for that they're requesting.
Okay, so they were under their square footage requirements. It's just the placement of
It's just the
additional
placement
one
on the
the-
rear of the building that doesn't face a street.
Okay.
And that was the part of the confusion earlier on, and Rick did his best to help corral us in the right direction and get us
Okay.
under that number. So that's where we issued that revised set, and you're not looking at the additional signs we had in the back originally.
Okay, so you're just trying to placard around the building.
Correct.
And what I got the impression of is that this Kane sign is really no bigger than the Dunkin' Donuts sign that's over their drive-through window?
I do not have that answer. I know it's 8 by 3 foot 10 inches, so it's not a very large sign in the grand scheme of what it's looking like.
Isn't that
on
your
there.
drive-through window you were talking about?
Correct. Yes, that is the drive-through side on the south.
Thank you.
Just a question, is it just painted or whatever, or is it lighted?
Oh, it's internally illuminated. It's internally illuminated.
Okay, thank you.
Any further questions of the commission? No. Hearing none, is there anyone in the audience that wishes to speak in favor of this application? Anyone that wishes to speak against it? Okay, seems like there's nobody. We have a motion to close.
Motion to close public hearing.
Second.
Okay, all those in favor? Opposed, abstained? Okay, so the hearing's closed. Do we have a motion to approve?
I make a motion to approve ZBA 2023-0407 90 East Elm Street, variance application of section 10.30.5 subsection BI of the zoning regulations to allow for signage to the rear south side of the structure where not normally allowed under the zoning regulations. Enfield Square Realty LLC, CO Enfield CH LLC, and Enfield Nassam LLC owner, Raising Cane's Chicken Fingers applicant, map 43, lot 28, BR zone, according to the materials submitted under ZBA 2023-0407.
Second. Is there a second?
Tim,
Yeah.
no.
Oh, I'm sorry, I did not
There
hear
is a
you.
second, sorry,
thank you.
Lori.
No discussion.
Any other comments before we vote? Okay, all those in favor signify by raising your hand. Opposed, abstain. Motion passes.
Reason?
Reason is the site has a hardship caused by the internal private road.
So you guys are good?
Yep, you're all set, guys. Thank you.
You got it.
Thank you very much. Good luck.
Thank you, guys.
You can sit here all night if you want.
You know.
Okay.
Mr. Chairman, I make a motion that we extend our meeting past 10 o'clock.
Second.
Okay. All those in favor? Motion passes. We're in overtime.
Sorry.
First, I want to give you this back.
Okay.
Madam Secretary, when you're ready, can we please have the legal notice for the next item on the
ZBA
agenda?
2023-05, 2365 Park Ave, applicant seeking relief from section 3.30.7 SS4, accessory buildings, Adam Hull, applicant owner, map 39, lot 27, zone R33.
Will the applicant please come forward and state your name and address for the record?
Good evening, this is Adam Hull, address 65 Park Avenue, here in Enfield. I'll try not to take up too much of your overtime. But, so I'll start by kind of reading into the record what I had sent. I think you all have the master packet, my pictures and all that, my application.
Yes.
So, I contacted the building department when I decided to build a greenhouse in my backyard to see if I needed a building permit. I was told if I kept it under 200 square feet and under 15 feet high, that I did not need a permit. I was not told I needed to contact planning and zoning at that point, and I was unaware I needed to get a permit from them. I admit legal documents confuse me, and I'm not a developer and in no way an expert in building or zoning codes. So after my interpretation of the zoning regulations, I thought that as long as I was in my backyard behind the principal building, that I needed to be 5 feet from the property lines. Now that I understand my lot is considered a through lot, I can see that the building is in violation of the zoning codes for through lots. However, the location in which I would be approved is an area of my property that floods regularly, and the ground is extremely wet there and may be considered small wetlands by some. The town of Enfield installed a drainage system before I bought the property where the drains are far above the area of my yard that floods, and I don't see how I could build anything in that area without major complications to the building or the town redoing the drainage system to actually drain the water from the area. So I'm seeking relief from the through lot zoning code, stating they have to be in the back fourth of the lot. To me, my backyard is just that. It's my backyard. Where my backyard abuts Westford Ave is part of my yard that's furthest from my house. That's on Park Ave, and I don't think anybody could build a house back there, so I never even considered that my backyard would have frontage on a street that's not my address. The day I received my violation letter, I immediately went down to the town planner's office to determine how to remedy the situation. I asked the zoning enforcement officer, what did I do wrong, and how can I fix it? Once the zoning officer informed me that my property was classified as a through lot and explained to me why it was, I realized my error, and when I asked him what do I need to do in order to keep my greenhouse, he told me I could appeal his decision, and he gave me the application and guided me on how to fill it out. He made sure that I understood in order to win my case, I would need to show a hardship. So I followed his instructions as best I could and fulfilled all the requirements. After my first hearing in front of you guys back in 4/24/23, I learned that that was not the correct path that I needed to take, and applying for a variance is really the best course of action to keep my greenhouse in its current safe location. I'm very grateful for the commissioners on this board for realizing that I was sent down the wrong path, and you decided to uphold the violation notice and allow me time to pursue the correct course of action. I would like to set one thing straight for the record. At the hearing in April, the zoning enforcement officer implied that I knew that applying for a variance was another path that I could take, and that I chose to appeal his decision instead. And then in the staff report and draft resolution for this hearing, it states that in April hearing, I was again advised that I could apply for a variance. But that is false. As I stated at the beginning of the speech, when I first talked to the CEO, the only course of action that was explained to me at the time was that I could appeal his decision, and he guided me down the path, and no other course of action was mentioned. I don't know this stuff, and because that's not what I do. I'm not a land use attorney, thank God, or a housing developer. If you need jet engine parts, you can come to me. I got you. You need to talk about manufacturing jet engine parts. I got no problem answering those questions. But because I make parts for the country's best fighter jets that help protect this nation. But if I have a zoning question, then I'm going to go talk to somebody in planning and zoning. And being a taxpaying citizen, I'm going to trust that person to inform me of the best course of action. So that's what I did, and I didn't really look into other courses of action. It was not until the hearing in April that I was made aware that I should apply for a variance. So thank you, commissioners, for allowing me to appear before you again, and hopefully for the right reason this time. Because if I was not a through lot, I believe I adhere to the zoning codes, and it was never my intention knowing to build anything in violation of the town codes, but I was just trying to follow the rules, and I just missed a step. So, the greenhouse we put up last year, and we barely finished it in time for winter, but it came in handy, and we were still allowed to was able to help feed my family through the whole year and reduce our grocery bill. And the greenhouse, of all the stuff that we grew, we had lettuce, kale, carrots, parsnips, all this stuff. We started our seeds early for the vegetable garden to ensure we have hardy plants for this year's crop. And You know, we've only been able to use a small portion of the greenhouse so far, but it's made quite a difference already. And, you know, we've always been able to share with our neighbors and hope that we're able to do so even more. But I would like to note that in the staff report for this hearing, it states that the photographs I submitted were taken in the winter months and may not show an accurate perception of water issues on the property. Well, the photographs were taken in late March and early April of this year, and even though there are issues throughout the year, however, they are much more prominent during the transition from winter to spring. So now, I don't believe that we had a bad winter this past winter, and you can see that we still had a large amount of water, standing water, on the property during that seasonal transition. That water remained standing for a good month to a month and a half before becoming dry enough to even mow my lawn. So I ask, you know, when do you think the most active time of the year is for a greenhouse? That would be the end of winter going into spring. You know, that's when we harvest a winter crop, starting seeds for the garden in the spring. You know, and I'm wondering, am I supposed to trudge through mud and standing in ankle-deep water to use my greenhouse? Is it a good idea to have a wooden structure sitting in water for extended periods of time? The ground is obviously sunk down from the water gathering there due to the fact that the drains are so far above the low part of my yard. You know, and I'm sure if a structure was placed in that area, that some kind of re-leveling would need to be performed regularly, or structural issues will ensue. Well, these are a few of the hardships that I would have to endure if not granted a variance. We spent many years collecting materials to repurpose for our greenhouse, and we picked a spot in our yard that appears to be safest spot and gets the most sun and relatively elevated enough to stay dry. I built it myself for the most part and in my spare time, and it took me most of a year to build it. So after thousands of dollars in lumber and materials and almost a year of blood, sweat, and tears, my hard work and dream are in jeopardy because I regrettably missed a step in the process. This has been devastating because I really thought I was doing everything right. Had I gone to zoning first, I would have appeared in front of this council to ask for a variance for the through lot zoning code before constructing the greenhouse. So basically, after the fact, I'm asking for that variance now. As I'm sure you can clearly see from the pictures I submitted in the master packet, or if any of the commissioners were able to see the property firsthand, the area in my backyard, which would be approved by zoning code, is not a feasible area to put a greenhouse, or any structure for that matter. The cement slab in my garage is slightly higher elevation, and there have been water-related issues with that. If a cement slab foundation can have issues from groundwater, I don't see how a structure at a lower elevation set on blocks is going to not have problems. For that area to sustain accessory structure, it would need many corrections made by me and the town. If not granted this variance, major modifications to the landscape would need to be made. This includes, but is not limited to, trimming of the next door neighbor's tree, removal of trees, and filling in the low area to stable the land. Since that area floods regularly, removing the trees that are sucking up much of that water would create more flooding there. Filling in the low areas would absolutely cause the water to be diverted to the surrounding neighbors' properties and could very well cause hardships to them. It would also affect the drainage system installed by the town, so now the town would have to redo the drainage system to make it work properly. It seems awfully costly and risky for both me and the town just to adhere to the code, especially when it seems the vast majority of my neighbors don't seem to have a problem with the greenhouse where it is. I have over 25 signatures on a petition from my surrounding neighbors that say they do not have a problem with my greenhouse at its current location. In fact, I was told by many of my neighbors that signed my petition that they love my greenhouse and think it's a great addition to the neighborhood. They don't see a problem with it, and it is my hope that this council will find the location of my greenhouse acceptable and grant me a variance in order to keep my greenhouse in its current location. And I thank you for your time and consideration on this issue.
Thank you. Before we open up to questions of the commission, I just want to read for the record when a variance may be granted, as that seems to have made its way out of our packets. So, a variance can be granted where such grant will not affect the overall purpose of the zoning ordinance and where strict interpretation of the ordinance will result in a hardship. A hardship exists where the zoning ordinance uniquely affects a parcel of land differently from other properties, and where use of the property or reasonable use of the land would be impossible without the variance. Self-imposed or financial hardships cannot, by law, be considered as a reason for granting a variance. And now I will open it up to questions of the commission.
I had trouble, and I was on your property today. Actually, I drove around your house about a dozen times. I thought for sure the cops were coming.
Should have knocked on the door.
Well, I thought for sure your neighbors were going to be like, what the heck? Anyway, I had trouble acclimating in your yard. What was your yard? What was your neighbor's yard? What was the front of your yard?
Blends together a little.
It was a little confusing.
Uh-huh.
And, I mean, I saw the greenhouse, so you didn't have to mark it. That I got.
I would hope so. That's pretty obvious.
Can you explain to me what the actual spot would be that the town would want you to move it to? Because your diagrams weren't helpful to me.
Right.
So, I was explained that you have this?
Hang on. Oh, is that the new one?
Yeah, it came in pretty like Friday, I believe. Yep. Mine's in color, but so if you hold it up here, here's Westford Ave, right? The cul-de-sac would be right here. Kind of got cut off on my thing. The greenhouse is right in from that. I was explained by Mr. Richelli that basically it would be if you cut a line in half of this lot, it would have to be on this half of the lot.
There's a brown building that I could see the back of. Is that your garage?
Yes, I have a garage that would be
Right here.
and my neighbor's garage is almost next to my greenhouse. Okay, so
There was an open lot. Like if where your greenhouse is here, if I walk this way.
Yep,
there's a
that's 71. That's
Is that your
that's
yard?
Ian, no, that's Ian Brown's yard.
Yeah.
Yeah, no, that's not him. He's this way.
Wait a minute. Right here.
Your property's L-shaped, essentially.
Correct.
Yes.
It's very L-shaped. It comes from Park Ave.
That's him. So he doesn't have this other little stuff.
So put your finger on the place that's supposed to be where you're supposed to put it.
So almost where you see grapevines, like almost on the other side of the grapevine where this big blotch is. If you see where the grapevines are from, on the western side of the grapevines, pretty much all in that area would be approved, is my understanding.
Back here.
Right. But before you got to the sewer, there's I called it the top of the
drain.
when you looked across the lawn, you could see the sewer.
Yep.
Grate.
Yep.
Okay. Is that still your yard? Neighbor's
So
yard.
there's a higher sewer grate towards the northern side. You can very well see. Then there's a lower circular grate that is on my property. That is
in here.
That's what this is marked right here. Yep.
Okay.
There's that connects to this town drain as well. So I have a town drain running almost the whole northern part, and a town drain running along the western side. And in that area is lower than all those drains. So it doesn't drain the water. It's like, I think I probably did better at one time, but as water settles in one area and continues to settle, it's just going to kind of keep going down.
You're doing show and tell here with our paper.
Yeah, huh?
I'm looking here, you're talking about right here is that kind of ideal thing. It's right above the, supposed to be blue tree. there.
Right above this blotch, there's another grapevine kind of thing here. This area is raised up a bit.
Yeah.
But also the town drain is like pretty much right under that. So
What about the circle here? It says maple tree. It looks like on your other.
So that would be on my neighbor's property.
But it shadows yours?
Correct. Yeah, it kind of almost busts through the fence, and part of it is on my property, the trunk, and then the whole shroud of it. That's what the dotted lines around any tree indicate.
That's what I was guessing, but you're basically answering my question. And that, based on that issue with the zoning, this is the only spot, it's in that corner that you can put it in, right?
Essentially, yeah.
That's
would be
that's what the language says. Am I correct on that?
That would be the northwest northwest corner of the property. We're north of the large tree and second grade wetlands area.
Okay.
Now, I was also under the impression, basically where this water spot is, would also be approval in that, almost this whole area, because my property then also continues down towards Park Ave from here. This is basically just my back lot, right? And then my property continues down. I might be a little clearer if we're looking at the town GIS topo map. I don't think so.
Come point to me where your property is, because I got lost, and you've got this little tiny lot, and I couldn't figure it out. So, I know that this is where your greenhouse is, I know this is the road. Is this you?
No, this is not me. This is my house right here.
That's your house.
That's my house, that's my garage, this is my driveway. And I come along this side of my garage.
Then here.
And this is
L.
my back lot here.
So that's not you.
Nope, that's not me.
Doesn't help.
Nope. And my property ends, this is a bush on this lot.
Right.
So I'm like, yeah.
Got it.
Yeah, it is a very odd shape and a little confusing.
This guy's yard is this way. Okay?
Is there a question?
No, just talking out loud.
Just trying to sort it out.
I got nothing else.
Nothing else? Okay. I guess I have a question for the applicant. Could you have moved this greenhouse back into where the area is that says garden and then flip-flop the garden to be in the front? Then you would have asked us for a much lesser variance.
Yes and no. Moving it forward would be closer to that one tree that's at the corner of the garden there. So it would also essentially put it more in the shade. That is a little bit, the whole yard kind of grades in that direction and then drops pretty significantly in the larger area. But, that also indicates I still have water gathers in that spot too as well. And these pictures kind of support that. If you're looking at this picture here is entering into my garden. That is exactly where this blotch is indicating. I get water that stands there too. So I can move it forward more, essentially, but I'm also looking, there's also, water issues there. Where I am is the highest level elevation of where I could have put it, thinking of the water reason anyway, and the most sun gets to that area, but.
Further questions of the commission? Vice Chairman?
Yeah, I'm reading this, the planning staff review, if I'm reading correctly. They're looking at it and saying that the topography was checked and the property appears to be flat at an elevation of 120 feet. I'm not disputing what you're telling me, I'm just, you were talking about
I
it.
don't really agree with that, being as here's your own map, here's my property, and there's this entire line right here. I don't know how you consider this all flat when here you go is the topo literally surrounding that area that I say is the low spot.
Do you have a top on that?
No. I'm trying to figure out what he's pointing to.
I know that's on GIS.
It shows the 120 contour. If I could bring it up to you if you
That
want.
basically surrounds
I'm sorry.
right around that area, right? So.
It's a 120 contour, and there's no deviation from that.
I believe you, just trying to picture it.
Yeah, I mean, if you said you came down to the property, did you notice when you were looking towards, there was that bush, it goes, and then it literally jumps up a little towards that bush at the end of my property going into the other lot. I actually have history of Mary Frangimore doing work to her lot to raise that up because of all the water issues. I actually have a lot of history about the water issues.
Want to give us maybe 50 pages worth?
I would never want to waste your time that way. I can highlight a couple things. You know, this was in the packet too. My father-in-law, you know, he wrote this up for me. So there's a part that says, you know, for the first 70 years, they had only a minor flooding problem in the spring, although the buildings out back surged one way and the other with the flow of surface water. And he tried to show a diagram back in the 1940s that's also back there too, that shows that they had buildings in that area, and that's what he's referring to, that they would move back and forth because of the instability of the land. They said the town would later put drains there, but the flooding of basements and buckling of cellar walls continued to be a problem. And that's what I was referring to with the cement slab of my garage, which is near that location as well, but a higher elevation. They've had buckling in the cement slab of that. So, and then frustrated Mrs. Frangimore, who is in the lot directly behind the one that you were kind of like, not the one you were questioning, but when you're looking from Westford straight back towards Harrison. Mrs. Frangimore is between Harrison and my lot there. So she took chunks of tar and she made a barrier and buried those in her yard and raised her yard up. So she put a barrier and brought in truckloads of dirt, causing our yard, my yard, meaning, to become the lowest point in that area. The problem was then made worse by the construction of a house and fill on the north of the lot. So the people where that maple tree is, they raised their lot up. So now that water flows in that direction as well. For years, they complained to the town, and after concentrated effort by the neighborhood, the town acted. They, instead of allowing surface water to flood our yard and allow children to sit in boats floating on the Harrison, they came up with a drainage solution. It hasn't been perfect. It's still wet and floods at times, and I don't know if they've ever cleaned it out. You know, so, and then again, he refers to Mrs. Mary Frangimore he said, when was the last time Mary Frangimore sued the town for water damage? Apparently, she did several times from this very groundwater issue, you know, because of the buckling of her cellar and stuff like that. So this has always been an issue of that water in that area.
Further questions?
Yeah. Looking at the staff report, where it talks about, it's at the top of the page, I can't see what, this page here, it talks about, finally, no accurate site plan has been submitted. Did you submit a site plan?
This is, when I saw that, I had drawn this up and I thought that this got submitted at that time, but I did submit this on Friday. This is my site plan.
Okay.
And this was my explanation. This is the best that I could do.
Okay, just to staff, is that an adequate site plan for this particular request? Just asking.
Well, I can tell you that I went out there today and I measured the 14 and a half feet is inaccurate. It's 12 feet 7 inches from the 4.5 foot property line. It's not a lot, but it's a couple feet.
You went there today?
Yeah.
You saw the flags that I
did
had
see
right
the
there?
flag.
That marked exactly the 4.5 feet from the curb?
And it comes to, I measured 4.5.
And then measure straight over there, yeah?
I measured 4.5 feet from the curb, and then I measured from that point, and it came out to 12 feet 7 inches to the corner of the building structure. So as for answering your question, we get similar type drawings. Whether or not it satisfies you as the ZBA, that's up to you.
No, I'm just, I know you guys ask us for something when we go to you, and I'm just wondering whether that meets the ask, that's all. The other question I have, you were talking about 4.5 foot from the curb line on Westford Ave, and then the department comment, the building department, they talk about, they noted that the structure is required to be 5 feet off the property line. I'm assuming curb line, property line are different?
Yes,
Okay.
it would be the front property line
Be on
Westford.
Westford. Okay.
Which I'm saying I'm 14.5 feet from, but he's saying I'm 12, we're pretty close, but still well over the 5 feet.
Okay. Thank you.
Further questions of the commission? No. Okay. Is there anyone in the audience that wishes to speak in favor of this application? Ma'am, come up. State your name and address for the record when you do.
Hi, my name's Deborah Dwyer, and I live at 14 Harrison Avenue. So my front yard looks directly across to Adam's property. I can see directly, well, bushes in the way, but straight over to Westford from my front yard on driveway area. And I can attest to the amount of water, and past 15 years, I've lived there for 31 years now. The water problem has significantly increased, where, thank God for sump pumps, because my house wouldn't be around right now if it wasn't for, I mean, there's a lot of water. That lot, all the children play straight through that whole area from Mary Frangemore. It's an empty lot, and then Adam's property is right after that. It's wet. It's wet for a long, long time. The greenhouse, it's not hurting anybody. It's not ugly. The kids, I love seeing that they're growing their food. They enjoy it. They come around, they, knock on the door, and they got all this fresh spinach. And I just think it's a shame to have to eliminate something like that, because it's the only place where he can put it. He's teaching his kids. It's really a good thing. It's not a bad thing. It's not ugly. It's not hurting anyone. I never knew that his backyard was actually a front yard. No one knew his backyard was a front yard. And that's all I have to say.
Thank you. Is there anyone else in the audience to speak in favor? Anyone to speak against? Come on up and state your name and address for the record.
Justin D'Elia. I'm the owner of 7 and 5 Harrison Ave. I'm also the property manager of 9 and 11 Harrison Ave, including Marie Francemore's that they're talking about. I'm engaged to her granddaughter. That's why I take care of all 4 properties in a row. I can tell you, at both my house and at Mary's, I have to regularly check sump pumps. I went and built a patio on the property that I have, the empty lot in between my house and Mary's, and I had to keep it out of a certain back part of the yard because there are 3 drainage that goes from my yard over to Adam's yard through Mary's, where I walk through. There is one at the corner of mine and Mary's. There is one at the corner of Mary's 2 lots, right where it butts up to the northwest section of Adams that you're talking about, where you can definitely tell if you were to walk back there, what he was talking about, how Mary took all the tar mats and actually built up over the years. So I'm sure you saw at the end of his property today, when you were looking straight back, all those big bushes on the other side of the tree. Those are all Mary's trees, her family's trees that I take care of. And they are, in fact, about a good 18-inch slope right there. So that whole entire area of Adam's backyard definitely does flood. Now, the other thing, that section of Mary's extra lot and Adam's extra lot that, was his wife's family's, those used to be deemed buildable until the town deemed them not buildable because of the water area. And I know this because I'm also the one that is going to be hopefully buying those 2 pieces of property. So I can tell you that Adam's piece of property, the only place for him to actually use any type of building is where he did, especially when it comes to a greenhouse. If he was to move it where he has that garden area, it completely eliminates half of it. Okay, I know my family and my kid, we all benefit from this. We all start our seedlings there for our gardens, everything else. You know, his wife definitely helps keep all the kids in the neighborhood, you know, well-fed and involved in this whole thing. And not just that, but, you know, as you can see, plenty of other people that benefit from it too. It really doesn't hurt. But the big real concern with moving this to any other section is there is no safe section to move anything. If anyone has ever done any type of building of any small deck, patio, small greenhouse like this, you know you can't put it where there's constant flooding. So you have not just those 3 drains, but as Deb was just saying that they have all the issues with water over there, the town had to put in 3 drains right in front of that other section on Harrison, in front of Deb's house, and in front of Mary's house, the property at the end. There are 3 drains right there. My house is one of the older houses in the neighborhood. I have to have a sump pump going, and because of the other houses around me that are built up, my property has a whole lot of issues with flooding. Mary's house is also built around the same time as mine. That's why hers has a lot of flooding. Adam's house and that property, they're all older houses in the neighborhood that have a lot of the flooding issues. And that back property and is honestly the lowest part in the whole entire neighborhood that, as Adam was saying, the drains are higher than where his ground is in that whole section that you would be wanting him to move that to. Also, I don't think it's really possible to pick up and move without dismantling the whole thing. But, you know, regardless, for variance wise, I don't see there would be an issue with anyone in the neighborhood. It's not an issue of safety. There is no one that lives, there's no houses that live right at the end of that cul-de-sac besides one across the street from it. As Mary, you saw today, there was an empty lot if you were to go straight down Westford. And then the lot to the right. There is no one that's going to be driving going down there at any type of crazy speed that could kind of hurt anybody down there of having a structure, you know? So the only real issues that I see is mostly the layout of the land, and there's nothing we can really do about the layout of the land with the drainage that the town has provided. So, thank you very much.
Thank you. Is there anyone else in the audience that wishes to address us on this matter? Hearing none, the applicant can come back forward. Do you have any final comments for us? Please give them.
I don't think so. I think I pretty much pled my case, you know.
Okay, thank you. Any further questions from the commission? Yeah, go ahead. Yeah.
Can I ask a question of the staff?
Absolutely.
Okay. Only because I'm familiar, I have some friends that live in that area, and they complain about the flooding issues. That's just my experience. But have you folks, from the comments here, it sounds like the town has had a lot of calls on it to deal with some issues, if they've put in all the drainage that's been talked about here. I thought one of the things I was surprised at was hearing that some of the neighbors have raised their property levels with added soil and stuff like that. And I'm wondering if there's any complaint, if that's true, if there's any complaints that coming in from other neighbors about the water. If you people are aware of that. No?
No, we're not. I mean, we haven't, it went out to engineering. Engineering didn't comment on it. We haven't received any complaints or any information about people filling in their yards to any extent. I mean, usually something like that, depending on the area, someone would call us on. You know, the more other people fill in the yard, the more the water's going to drain a different way.
Yeah.
It's going to change the course, especially underground. So, but for the past 10 years, I haven't had any complaints.
It's part of the reason I don't want to have to raise my yard up, so I don't push my problem onto my neighbors.
No other further questions from any of us?
No.
Do we have a motion to close the hearing? All those in favor?
I'm sorry, who was the second? Thank you.
Discussion?
I just know that the complaints about water that at least I hear from people that I know pretty well. I hear them all the time, and I'm just wondering what the option, if there are any other options other than moving it to that other site, which appears not to be an option.
I guess the question from my standpoint that I think we should think about is this the minimum amount that could satisfy this, or could a shift of this project back 10 feet give us more of a setback on the road? And is that plausible?
I'm not sure that the setback requirement is the issue. I think it comes down to where would the greenhouse be able to go? I went and did some research about greenhouses. I probably cannot find the paper. But it talked about where it needs to be placed, the sun, the needs. And truthfully, after walking again on your property,
Yep.
don't get me wrong, I don't think it should be where it is, but I don't think you have any choice to put it where it is. I think the land is causing you your problem, which is the only thing that we as ZBA can focus on.
Thank you.
Anything else you told us, the financial
yeah.
is not
I understand that, yeah.
plausible to us. So having looked at it, that's what I'm seeing. I'm seeing the property is causing you your problem. If you were to do it over and you had asked us a question before, we probably would have reconfigured you a smidge, but I don't think in the end it's going to get you much further from where you are.
I agree. Thank you.
Any other discussion? Do we have a motion to approve?
I have a,
Go ahead.
do I need to read it?
You can read it if you make it. Yeah, sure. Doesn't matter.
Would you like to read it?
No, go ahead.
Okay. I make a motion to approve ZBA 2023-05-23, 65 Park Avenue, to approve a variance to allow for an accessory structure to be located in the front yard setback of Westford Avenue where under section 3.30.7 subsection A 4 on through lots, any accessory structure to be only located in the fourth of the lot farthest removed from the street.
Yeah. Do we have a second?
Second.
Okay. All those in favor? All those opposed? None? Motion passes. And the reason is that there is a hardship due to the shape, topography, and drainage.
I just got my potatoes to sprout.
Beautiful.
I was very excited.
Thanks, you're all set.
There's nothing else I need to do. We're all set. Thank you so much. Appreciate your time.
Thank you.
Would you like to go make a fire log?
Okay. No, I've lost my agenda. We have one more item.
Here, guys.
Yeah, we got another one.
Madam Secretary, could you please read the next item on the legal notice?
ZBA, do we need to push it again? Do we need to push the time?
Mine's going to be quick,
Well, it's 10:30.
You okay?
I think we'll be over.
ZBA 2023-06-08, 66 Enfield Street application for automotive location approval. Joel Wheeler applicant, 66 Enfield Street LLC owner, map 35, lot 45, BG zone, and you're not a public hearing.
Correct. So he just needs to come up and chat with us. Yep. Filing. please give
Hello.
us your name and address for the record.
Sure. Name Juan Scott. Personal address 151 Bakos in Holland, Connecticut. Business address 27 Palumba Infield, Connecticut. I'm not Joel Wheeler. I'm here representing his business. I run a few of his companies. There's a letter of permission and hopefully something that you'll have in front of you. And we are purchasing the second business in town for the sake of continuing day-to-day operations as they already are.
I am confused about the address.
Oh, sure. Oh, I probably said 27. I'm sorry. That's my other store. We have 66 Infield Street is today's matter.
But 66 Enfield Street, when I went out there and looked, is the Meineke building.
So it's not. It's
And when you turn, and
Yeah.
you go on to, and the building that says the Motorsports says on the door 70.
Yeah, it's so confusing. It's taken me months and $15,000 to figure this out. So the entire building,
The L?
the L, is noted as 66 Infield Street physically. 70 is the mailing address. Meineke has, again, it's all for the purpose of multiple businesses and mailing. Yeah, so 66 is the physical address.
That was the only thing, because I noticed they had tires out, not that this has anything to do with you, but Mr. Zoning Officer. There's tires and
When was this?
blurry things all over the ground out.
Oh, on maybe this, on the other property, yeah, okay. Because I've since removed a lot from the operation of the business that I'm here today for.
I don't have any problem. You want to tell us a little bit about the business?
It's a power sports dealership, motorcycles, ATVs.
Not
We
the
also,
one that's over by the post office.
no, but my company owns that as well.
That's what
Yeah, same company. Yeah, we're just doing the same thing again.
Okay.
Yeah. Nothing's changing at this time. We're just running the business as it already was.
Gotcha. Any question? Oh, yeah, go ahead.
Yeah, so you're really just changing the ownership and the signs?
That's it. Ownership signs aren't a today thing. They will be. I'll probably see you again for that. But we're not even changing that at this point. We're just simply changing the ownership. We have filed the DBA and the trade name certificate and all that accordingly. But yeah, this is purpose for today, of course, is to move forward with the DMV license. We do register on-road vehicles.
Any further questions of anybody? Okay. We have a motion to approve.
I have a motion to approve ZBA 2023-0608, 66 Enfield Street, suitable approval for an automotive dealership sales limited repairs to motorcycles of Manchester doing business as Moms Inc., Joel Wheeler, applicant, 66 Enfield Street, LLC, Mark Burjack, owner, map 35, lot 79, BG zone, according to the materials submitted under ZBA 2023-0608.
Do we have a second?
Second.
Okay. All those in favor? And there's none opposed.
Reasons, existing business,
Yeah, continuation of similar operation to existing business. You're all set. I mean,
Okay,
if you
yeah,
wanna
thanks.
go.
Appreciate it. Next time I'm gonna request to go first, okay? Is that allowed? Can I do that?
Yeah.
Thank you, everyone. I appreciate it.
Thank you, have a
luck
good one.
with your new business.
Thank you. Have a good night.
Absolutely.
Oh, you know what? I have the case 7. Do you want that? Yeah, just thank you.
Okay. Moving on to the agenda, approval of minutes.
Can I sign that while I'm here? The K7? Okay, the only thing I'm asking is, I'm gonna be leaving to go back out of town. No, I'm gonna be here for the next couple of days. If we could do it before I go back out of town again.
Tomorrow's fine.
Tomorrow's perfect.
I'm all set? All right, thanks so much. Thank you.
Okay,
Not,
next.
I can sign it.
I just wanna make sure we keep the guy moving. I guess we're
Yeah,
under approval.
approval of minutes, yep.
Oh, I found my greenhouse
Do you have any
words.
discussion?
I had a couple of just minor typos.
Okay.
Minor typo, page 3, under new business. Last paragraph, it says Commissioner Turner clarified Mr. Hall. It should say, if he wants to go further, he will need to go back to plan and zoning or apply for a variance, not and. I don't think it's supposed to be and.
That makes sense.
And then on page, 5, first sentence, Mr. Raffia asked, why did the complaint no come, it should be not come. Not come 13 years ago when he purchased it. And a couple on the next side, page 6, same minor thing. Second paragraph, last line says a happy medium, but no, it should be not have it expanded to a bigger business. Is that making sense?
Yeah.
Just minor things. Good job, Secretary.
One more thing, back on number 8, Mr. New Business, it's Hull, Adam Hull, not Hall. So the second,
For the rest of that section, just needs to be changed.
Yeah, that's a consistent typo.
yeah, except for the first time it says Hull.
Oh, okay.
Make a motion to approve minutes based on the edits noted.
Okay.
Second.
All those in favor?
Aye.
Okay, the motion passes. Do we have correspondence, staff reports that we need to discuss?
I know.
Well, the appeal fees. You
Yeah.
want to talk about that?
Yes.
Go forth.
So you should have a list there of what the area towns or similar sized towns charge for appeals. Sometimes, in some cases, maybe even some tonight, people choose to do an appeal because it doesn't cost anything, as opposed to filing for a variance. So we're one of the only towns around here that doesn't charge for an appeal.
Yeah, I remember when we had this big discussion.
That's why we're getting them all
went
the time.
back and forth. No,
Free.
no, I don't think that's it, but I don't remember why, Andrew, we even had the discussion when we did. Do you know what drove it? I don't remember.
We felt that the town was the person that was pushing it forward so that they shouldn't have to pay to defend themselves if they couldn't. It was something to that effect.
Right, but I don't know why it even came up, because the dollar amount is not large.
No, we had somebody in that shouldn't
Was that
have
it?
been before us, and we were then not able to refund the
Oh,
money.
they weren't supposed to, right, that was the drive.
Right.
Somebody got here and had to pay to get here, and in the end, they weren't supposed to be, they really shouldn't have been here at all. Is that what it was?
Yeah, I mean, it was something we disposed
So
of
then
in a
we-
minute or
okay,
two. It was
okay,
just
yep.
a
So then we-
series of errors led
Right.
them.
Well, I can see, on the other hand, though, that I can see we've probably haven't solved a problem. I think we've probably created a problem. Everything has value.
Right, I think there needs to be some kind of fee.
And that was the reason why
Does
I
it?
asked the dollar amount, and you said they're the same fees that we charge for an application for variance, that when you came back to me today.
Correct, those were the old fees that were charged.
Fee for the appeal,
120 and non, for residential and 185 for
which are the
non-residential.
same prices we charge for the application of a variance.
Correct.
Oh, I thought they might have been different. Truthfully, I agree with the zoning officer. We definitely should put them back in. I think we test cased it, and I think where we are today, we need to, everything has a value.
Yeah, no, certainly, and it's a cost to the town that's not being recovered. And I think that's,
And it's not gonna, even that $120 is not enough.
I guess the question is, do we just put the $120 back for today and then put this on a future agenda to discuss maybe what the fees should be increased on for both?
'Cause that-
We can certainly do that.
Yeah.
Is it in our purview to adjust that, or does that have to be done at another level? No.
No, it's us.
We actually have to go back to the council for
That's what I thought.
modification to fees, I believe.
Right, but we have to give it to them.
recommendation.
Yeah,
ZBA was
we have
empowered to
to
do it on their own.
put it forward and then.
I think so in the
and then they can do
bylaws.
that.
Okay. You might be able to do it yourselves, but we'll have to double check. But it would make sense to go back to the fees that had been previously
Original
approved.
fees. I think
Right.
that we had our
And-
reasons when we did it, but I think that we've proven that there probably wasn't in the end, what's that they say? Be careful what you wish for? or-
Yeah, well, it didn't give us the desired effect, I guess is what I would say.
So is it something that we can make a motion on
Yes.
tonight?
I believe so,
mean,
yes.
You can find out whether we can do it or not, or we have to go to the council?
Well, we
No,
got
I-
rid
I
of them,
think you
so
could
we can put them back.
Yeah.
It's
We
just
get rid
if
of them without
we,
going to the council?
Right.
Oh, all right.
we only, I think the council's permissions needed to set the rate. If we want to change the rate, I think we have to put that forward to them. But in terms of whether we have them or don't, that's us.
Yeah, I think you could reinstate them tonight.
Yeah. So do I have a motion to?
Make a motion to reinstate fees for the appeals
Okay.
at the previous rates.
Yes, and seconded by Vice Chairman Neville. All those in favor? All right, the motion passes. And if there's. is there
One
any
more
other-
thing?
Yeah.
If you don't mind.
Oh,
The next meeting is scheduled for July 24th, I believe.
Yes.
And there's another appeal that's going to be coming to you on enforcement. And I'm going to be gone I'm going to be gone for 2 weeks. So I'm wondering whether or not you would consider moving the date up to the prior week, the week of the 17th to the 21st. 17th would be the Monday.
hang on. I probably have the same problem you do with the original date. I don't have an issue with the 17th. Does anybody
No,
else have an issue with the 17th?
I think that's fine. Yeah,
What about you, Charlie?
Hold on a second. What's the date you want?
17th. is
July
what we moved it to.
17th.
So we're moving
Open now.
We're moving it up a week.
Right, so we would need a motion to.
Motion to move the July meeting to July 17th.
Second.
July 24th to July 17th.
Second.
All those in favor? Motion passes. We've changed the meeting date. And is there anything else? Or do we need a motion?
Just in case.
Okay.
Oh, the K-7 update.
Yep.
So legislation made it through the process. It got through the Senate. It didn't seem to work quite well in the House because we ended up with a bill which is literally the same bill that we already have that they voted on. And I'm like, you people aren't hearing me. Well, when I talked to them, they sent me something in an email, Lori, and basically they everything's exactly the same. There's nothing different.
The bill that we saw shows that everything is out of the ZBA's hands and into the zoning enforcement officer's hands.
Nope, that's not what I saw.
That's what we saw.
I'll have to
That's
look.
what the town attorney saw.
I was talking to the
So you were
legis-
effective, Mary Ann.
But it didn't solve the problem, Lori.
Oh, it didn't solve the problem,
The
but you were-
ZEO has no more legislative powers than we do. It has to go back to planning and zoning.
But it did not. As far as we know, it's now in Rick Rochelli's
Something
hands
else.
because he's got nothing else to do.
Right, well, I'm going to go back and look because I got an email about it, and the way they wrote it to me is that nothing changed. And I said, I said to him, can we sit down and talk about this? So we're going to schedule a meeting prior to the next legislative cycle for another go-round.
I think it was House Bill 408.
Yeah, I'll go look. But anyway,
We'll
Didn't
send
get-
out what we received to
yeah, and I'll look
the
at what they
ZBA.
sent me from in the email. But testimony, I don't really think they really know.
Okay. Well, thank you for the update, Mary Ann. I guess we're on to motion to adjourn.
Motion to adjourn.
All right, we are adjourned.
Okay, we have one problem.